item number 1.
Item number 1, Your Lordship. This matter arises out of Orissa State Abolition Act. Your Lordship, the order which is challenged here is the order of the member Board of Revenue passed in OEA revision case number 27 of 98. Kindly, my Lord, let me place the facts of the matter. The disputed land was purchased by the petitioner's mother via sale deed dated 27/5/1978. The sale deed is in Annexure 3A. The land has been being used for cultivation. The father of the petitioner and his sons were looking after it. On the said land, since 1978 to 1995, the government has received water rent and other various government dues. Then suo moto, according to OEA proceedings, the OEA Act was initiated for settlement of land. The notice was previously the petitioner's land belonged to one Mrs. Khali Patra. When this proceeding was initiated, the notice was issued to the old owners rather than the current petitioner, my lord. As a result, Khali Patra, who has transferred his right title and interest to the petitioner, did not appear, and the petitioner, since has not been noticed, did not appear as well.
So there are two petitioners here.
Right, my lord.
You're using in singular.
Right, my lord. They both are brothers.
So they become one person, or they are
one
still
person.
two persons?
I'm one person.
They're only one person. They're not two persons.
Two person. Sorry, my lord.
Please be clear in your facts, sir.
Sir.
Are there two petitioners or one?
There are two petitioners.
Yes. Don't use singular where you have to use plural.
There are two petitioners, and there are also the petitioners before the court in revision case.
Sir, sorry, my lord, the appeal was preferred. The appeal was preferred the Tehsildar dropped the case because there was no appearance. So because it was not noticed, the petitioners came to know about the case and they filed an appeal, being petitioners. But on the ground of limitation, it was also rejected. The limitation was one year or 5 to 6 months. Many judgments, Your Lordship, where these delays are condoned, but my delay was not condoned. Again, they preferred a revision, OEA revision of 1 of 1996 at the Honorable Court of ADM Ganjam, which was also dismissed because of this.
Let's read that.
Yes, Your Lordship will. Copy of the order in OEA revision is on page 38, madam.
Yes.
Your Lordship, after such dismissal, the Board of Revenue was referred to for considering this case, where an order under Annexure 1 was passed. So, Lordship, my prayer is.
First, let's see the order of that ADM.
Page 19. No, my lord. The order of the Board of Revenue is important. Running page 19 at 11 paragraph. He has discussed why he has no title over the land in question.
Yes.
Petition page 19, paragraph 11. Impugned order.
Yes.
The order sheet of the OEA case number 4 reveals that the estate was vested with state government on such and such day. The claim in this case is on purchasing the land through a registered sale deed dated 27/5/1978. After vesting of the estate, the lands gets vested with state government unless and until the Inam lands are settled with the intermediary or tenant, as the case may be. Any transaction subsequent to the date of vesting by means of sale, mortgage, etc., cannot be deemed to be valid.
Lordship, while I was
on the basis of this finding, his claim was negative.
As I was not noticed. Initially, only I was not noticed.
No, but now what is your case and merits, sir? Now you've gone from one forum to the other. So what is your case and merits? You tell us.
Your Lordship, my only prayer is that at least they should have noticed me, at least give me a chance to.
If you have a statable case, then we can send you back.
No.
But if you don't have a statable case, then there's no question of sending you back.
In the last court, before the revision, they were the petitioners.
Correct. That's what
they were the petitioners. Yeah. They have raised all their points.
Right.
And it was ultimately held that the sale deed is invalid because of
also, Your Lordship, after submission of the same, the OEA revision case, in that OEA revision case, the member of board reviews passed this order after a year. A delay in judgment, I have got judgment where.
What is your case and merits? You're not able to tell us. All these are technical points you're giving us. If your sale deed is 1978, the vesting took place in 1965, how do you have a case?
Your Lordship, the Khali Patra, the person who had the land under her possession, she already had it before
No,
1965.
no. After after the vesting, there can't be a sale deed.
After the vesting, right title interest in respect of the immovable property will vest on the state
Exactly.
and free from all encumbrances. That is the law under the OEA Act.
Your Lordship, kindly tell the appellate authority to kindly consider the matter.
For what, sir?
And decide. They may decide on merit because
They've already decided on merits. You're not able to say what is wrong with para 11. Para 11 is decision on merits. All right. The present petition challenges an order dated 4th May 2002, passed by the Board of Revenue Orissa in OEA revision case number 27 of 1998. By the said impugned order, the Board of Revenue upheld an order dated 27 June 1997, passed by the Additional District Magistrate Ganjam Chhatrapur, bracket ADM, in OEA revision case number 1 of 1996. Paragraph. The background facts are that the property in question is situated in Moza Sihala Tehsil Kanisi. Moza Sihala Tehsil Kanisi, subdivision Berampur, district Ganjam, and is located in Khata number 41, lot number 279, to an extent of AC 1.052, comma, in plot number 335 to an extent of AC 0.204, totaling AC 1.256. Paragraph. Hereafter the plot in question, bracket, full stop. The said plot in question was apparently purchased by the present petitioners. Mother, under a registered seal deed dated 27 May 1978. Full stop. The claim was that the father of the petitioners had been cultivating that land, and after his death, it had passed on to the present petitioners. Full stop. They claim to have also been paying the government dues and water rent, etc.
Till 1995, Your Lord.
Yes. Claiming that the ROR, record of rights in respect to the land in question, was wrongly recorded in the name of one Khali Patra. and that he had wrongly instituted OEA case number 184 of 1991 before the Tahsildar, in which an order had been made without notice to the petitioners on 18th December 1993, the present petitioners filed an appeal being OEA appeal number 2 of 1995. Full stop. The said appeal was dismissed by the sub-collector Perampur on 22nd November 1995 on the ground of limitation. Full stop. Agreed by the said order, the petitioners filed OEA revision number 1 of 1996 in the court of the ADM Ganjam, which came to be dismissed by the order dated 27 June 1997. Paragraph. The perusal of the impugned order reveals that while the Board of Revenue has dealt with the question whether the petitioner's plea could have been rejected on the ground of limitation alone,
petition won't be valid.
The Board of Revenue has nevertheless proceeded to examine the merits of the matter.
Paragraph 10 of the writ petition.
Full stop.
It
It has been noticed in para 11 of the impugned order as under. Reproduce para 11, page 19. Paragraph. It has been correctly concluded by the Board of Revenue that again reproduce para 12, again page 19. Paragraph. Learned Counsel, the petitioner urges that the petitioner's appeal and by the was rejected by the sub-collector only on the ground of delay, as was the revision petition before the ADM. Full stop. In other words, he submitted that in the initial stage, since no notice was issued to the petitioner by the Tahsildar, the petitioner's case and merits could not be appreciated by any of the authorities. So he accordingly prayed that the matter should be sent back to the sub-collector ADM for the petitioner to be heard once again in the matter. Paragraph. However, counsel, the petitioner has no answer to the finding on merits of the Board of Revenue, as has been extracted herein before. So if indeed the land in question stood vested in the government on 1st October 1965 itself, then the question of the petitioner getting title under a registered sale deed thereafter, nearly 13 years thereafter, does not even arise. Full stop. The petitioner has no answer to this legal difficulty.
Paragraph 10
and
of the
unless he is
petition.
able to overcome it, the question of sending the petitioner back to any of the subordinate authorities would serve no purpose whatsoever. Paragraph. Since on merits there is no case made out by the petitioner, the court is not therefore inclined to interfere with the impugned order of the Board of Revenue. The petition is accordingly dismissed.
Lordship, one last. In the paragraph 10 of the writ petition, they talk about the previous ownership prior to 1965.
That's okay, sir. You're not that. Your locus is only from under the registered sale. All right.
Any liberty to approach, my lord?
Sorry, sir.
Weekly list item number 2.
Here I am appearing for the appellant. Management. In fact, this writ appeal arises out of a rejection of an application filed to decide the maintainability of the reference as a preliminary issue. In the meantime, during pendency of the writ appeal, that IT case has been disposed of.
All right. In view of the subsequent development where the IT case itself has been disposed of, ID case number 68 of 2001 has been disposed of. The present writ appeal has been rendered in practice. It's disposed of.
Weekly list item number 3.
My lord, item number 3, my lord. It's a remand order, my lord. Against the remand order, the only point your lordship may turn to page 34 of the brief, my lord. Only short point. My lord, while remanding, my lord, to sum up our above discussions, I find the dealer to have entered into an individual contract for complete design, supply, erection, and commissioning of the fire protection system at Paradip. There is also no sale of materials in the course of interstate.
By now, there was no stay of this order.
Your Lordship,
There was no stay in all these 15 years of
Yes, ma'am.
pendency of the present petition.
Yes, my lord.
There was
No,
no.
amount has already been paid. So I will get refund in case it is my opinion.
Will you permit me to complete my question, sir?
I'm sorry, my lord.
With your kind permission?
Yes, I'm sorry.
This order which you have challenged is dated 2007,
Yes, ma'am.
correct?
Yes, ma'am.
Or even earlier.
Yes.
What is the date of the order, sir? The order which you are challenging, what is its date?
Your Lordship. 8,
It relates to 85
12,
No,
4,
sir, kindly give me-
assessment year
Sir,
85.
kindly, sir,
Yes,
kindly follow the question I'm asking you.
Yes, my lord.
Kindly give me the date of the order that you are challenging.
It is 12/4/96.
How many years ago, sir?
12/4/96.
What is my arithmetic is not very good, sir. You can tell me how many years ago?
And
How many years ago, sir? Just tell me.
26 years.
In these 26 years, there has been no stay of that order.
No, amount has been paid.
1 minute, sir.
Yes, ma'am.
There has been no stay of that order.
No stem.
In these 26 years, would that order have been worked out?
No, after remand not taken up.
For 26 years, not taken up.
Yes, ma'am.
How do you know? How do you know that? How are you so confidently saying it?
My lord, because I should have got an instruction from my client.
Well, so what? If your client doesn't give instruction, doesn't mean that it's not, it's still pending. Impossible, sir. For 26 years, a remand order is, they have not passed a fresh order in remand without there is a stay from the High Court. What are you saying? Inconceivable.
If it survives, I have no.
What is that? If it survives,
Do
then
not know
we
if-
both should now sit and give a full judgment without your knowing whether it survives or not. You say the challenge in the present order is to an order dated 28 November 1996 of the Orissa Sales Tax Tribunal, remanding the matter to the assessing authority for a fresh decision. Full stop. Initially, this petition was registered as SJC number 57 of 56 of 1997 and was later converted as STREV 68 of 2007. In other words, the present petition has been pending this court for 25 years. Will stop during this long period of 25 years. There has been no stay of the impugned order of remand. Paragraph, it is impossible that the impugned order has not already worked itself out. Full stop, clearly the matter has become stale and there is no need for this court to interfere at this stage after 26 years with an order of remand. The petition is dismissed.
obliged.
Same order next time.
Weekly list item 4.
Same order. In view of the dismissal by order today of STREV 68 of 2007, the present revision petition is also dismissed.
Weekly list item 5.
5 and 6, may it please the lordship.
Yes, please.
The petitioner is before the NCLT.
Then that's okay, sir.
Sir.
In both these petitions, just put them together.
5 and 6.
Both these petitions, you say counsel for the petitioner informs the court that the petitioner is before the NCLT. Consequently, these petitions cannot proceed. It will be open to the petitioner to approach the NCLT for appropriate reliefs.
My lords. Then, my lords, item number 7,
Yes.
your lordship will kindly see the question of law was admitted on 1st of December. Sorry, 3rd of December 2007. Whereas it relates to the assessment year 92-93. Now in the OST regime, it is gone.
Correct.
Thereafter, my lords, VAT regime came.
Correct.
VAT regime gone.
Correct. GST has come.
GST has come.
Right.
Now, my lords, the past management, that is also gone.
Only Mr. Siddharth Rai is a common factor.
Your lordship.
Only, my lords, after your lordship assumed the office of the Chief Justice, these matters are being listed.
Correct. Correct.
And it is also very difficult on our part, first to trace out the file. And the second part is, my lord, nothing to say, lordship knows, about the monetary part.
Correct. Correct.
It's also difficult to...
Leaving, you say, view of the reflex of time.
Lordship may kindly only leave
the questions
open.
Yeah. The questions are left open for decision in appropriate case.
And
I was thinking in a lighter vein, we have started a judicial history project as a high court.
my lords,
Because we are coming across records of 1808, 1814.
correct.
So I think in each of the lawyer's office also you can start a history project.
Your lordship.
These are the cases, my lord, where my father used to...
Yes.
Your lordship, yesterday one case I had argued. In that case, I have mentioned that it was 70 to 73 assessment year.
Right.
The Honorable Justice Dr. Arijit Pasayat, he
Yes.
is an advocate in that case. Your lordship. And in the meantime, he has elevated to High Court, Honorable Supreme Court, and retired, your lordship.
And now you are lucky. You are lucky to handle that brief. My lords, only after your lordship assume, some cases are being reported.
Right. All right.
Much obliged.
All right.
Weekly list item number 8.
And no instruction, my lord.
No instructions disposed of.
Weekly list item number 9.
Your lordship, item number 9. So-called notice has not been issued, your lordship.
Yeah, no show cause notice has been issued for the last 15 years and correct address has also not been furnished.
10 also.
The petition is accordingly dismissed. All right.
Weekly list item 10.
10 also same thing.
Same.
Weekly list item 11.
Item
Again.
11, your lordship, 35 days delay, but only the effect is 64,045.
All right. Delay is condoned in view of the insignificant tax effect.
Your lordship, item number 12,
12.
88,433 defect has not been removed till date.
Right. Defects have not been removed for 14 years now.
And also notice has not been issued.
Yeah. Notice has also not been issued. The tax effect is minimal. All right.
Item 13.
Item 13, 13,183, your
Yeah.
lordship.
Insignificant tax effect. Right.
Item number 14.
Your lordship, item number 14, that is 20,053. Also limitation also is there.
Right.
Weekly list item 15.
Item 15.
No instruction.
No instructions
No,
dismissed. All right.
Weekly list item number 16.
None appears dismissed on prosecution.
Weekly list item number 17.
None appears dismissed on prosecution.
Weekly list item number 18.
18, 19, 20
Yes.
and 21.
Yes.
And here we have not filed the certified copy of the impugned order.
All right. Certified copy of the impugned order has not been filed in the last 11 years. Steps have not been taken to cure the defects. The appeals are dismissed.
Item 21.
Well, 21 can be taken up with the 69 of 2011. It's a connected matter.
What's it about? You tell us.
This is students were admitted in there is no college, students were admitted without affiliation of the college. Well,
There's no stay, sir.
I
There's no
believe
stay.
this too might have become
Yeah. You say there has been no stay of the impugned
can
order
be taken up
for the last 11 years. Clearly, the case has become infructuous by a flex of time. The appeal is disposed of. When that other appeal, you take it on board. You say appeal 69 of 2011.
any day, man, Friday or any
No, today itself, sir. Same matter.
No.
Only
to be disposed of.
Same order we can pass in that.
Must have been rendered
taken on board.
infructuous.
Same order in 69 of 2011. Also.
Can be disposed of
same
together
yes.
Because rendered infructuous. I believe it rendered infructuous.
Correct, sir. You're correct.
Weekly list item 22. He has mentioned that. 22 is
22 also, we have
Same.
not filed the certified copy.
Yeah, certified copy has not been filed. Yeah.
weekly list item 23.
None appears dismissed on discussion.
Weekly list item 24.
None appears
No,
dismissed.
Lord, item 24. The
Again.
file is not.
Anyway, this is the appellant is not here.
Weekly list item 25.
No instruction.
No instructions dismissed.
Weekly list item 26.
26, I am for the appellant, my lord.
St. Vincent Convent.
Oh, I'm sorry, I'm 27. I'm sorry.
None appears dismissed. No.
Weekly list item 27.
27. In the impugned judgment, only thing I find that the order of the settlement officer was passed against a dead person. And it was very much available, the information was available, but without substitution, the order was passed.
Yes.
But the learned single judge, without taking note of that, on merit, only thing in my, your lordship may kindly have a glance on my grounds, memorandum of grounds. Page 7 of the appeal memo, D. For that, the Honorable Single Judge has also committed an error of law in holding that due to non-substitution of the father of the respondent during the pendency of the appeal before the settlement officer, the order under annexure may not be sustained in the eye of law. The Honorable Single Judge should have held that non-substitution in the order under annexure 1 requires fresh consideration, and in the present case, the Honorable Single Judge should have remitted the matter back for carrying out the substitution and re-adjudication by the settlement officer, but having not quashed the order, has acted illegally and as such the impugned judgment violated. So, what my humble submission, the Honorable Single Judge should have remitted back for substitution and again hearing the matter. And without doing so, and another thing, the point which I have raised at page 8, paragraph 8, the Honorable Single Judge had failed to appreciate that order passed by the Tahsildar Bhubaneswar without the confirmation of the Board of Revenue, which was requirement of law, was honest in the order. There is a Tahsildar's order which was negatived by the settlement officer. And by the time the settlement officer passed the order, the person was dead. And without substitution, the order was allowed. And that was interfered by the Honorable High Court by saying that he had no jurisdiction under section 22 to revise a record of right which has been published by the Tahsildar under section 12 of the OSS Act. So without going to the merit of the case, if the person has...
You are for the opposite side, sir.
No. Nobody is appearing.
Despite service, none is appearing, sir. You say despite service of notice, none is appearing for the respondent. The challenge in the present appeal by the Director of Estates as well as Tahsildar Bhubaneswar and the estate officer is to an order dated 17th March 2011 passed by the Learned Single Judge allowing writ petition civil 9033 of 2008 filed by the respondent. The case of the respondent was that
The settlement officer under section 22(2)(b) of the Act has no jurisdiction to correct the record of right prepared by the settlement.
The background facts are that the respondent filed the aforementioned writ petition aggrieved by an order dated 8 November 2007, passed by the settlement officer Cuttack in appeal case number 371 of 2004. Full stop. The petitioner's father was the respondent in the said appeal, which was filed challenging the Record of Rights (ROR) published under Section 12 of the Orissa Survey and Settlement Act. For seeking correction in the entries made in the ROR in favor of the father of the present petitioner. Stop. One of the questions that was raised before the learned single judge was whether the order in appeal could have been passed against the petitioner's father, who had expired by the time the order came to be passed. Full stop. In other words, could such order have been passed without substituting the respondent, i.e. writ petitioner, in place of his father, who was a respondent in the said appeal? Paragraph. Two objections were raised before the learned single judge. One was that the writ petitioner had in fact been served with copy of the notice in the appeal. Full stop. The learned single judge noted that there had in fact not been any substitution of the respondent in the appeal by the writ petitioner in his capacity as son. Paragraph. The second objection was whether was that a remedy by way of revision was available under Section 25 of the Act against the order in appeal. However, the learned single judge rejected that plea on the ground that the order in appeal was entirely without jurisdiction. The only plea raised here is that even while quashing the order in appeal, the matter should have been remanded to the appellate authority to proceed afresh after issuing notice to the present respondent. Full stop. Indeed, the failure to carry out a substitution of the respondent to the appeal by the present respondent, who was the legal heir, is a procedural error. Full stop. Therefore, while the quashing of the order in appeal by the learned single judge cannot be faulted, there is merit in the contention that the appeal should have been restored to the file of the appellate authority for being proceeded afresh after issuing notice to the legal heir of the respondent. by first substituting the deceased respondent with the legal heir. Paragraph. The learned single judge appears to have overlooked this aspect of the matter. Paragraph. Consequently, while not interfering with the quashing of the order and appeal by the learned single judge, the court directs that the said appeal case number
371
of 2004 will stand restored to the file of the sub-collector.
No, settlement officer, Katak Puri Major Settlement, Camp Court at Bhubaneswar.
Yeah. Settlement officer, Katak Puri, Major Settlement, Camp Court at Bhubaneswar, for being proceeded with in accordance with law. The case will now be listed before the said officer on 26 September 2022.
And the court below will notice the legal heir.
Yeah.
That is the presence.
And the said authority will proceed only after carrying out the substitution of the respondent in the appeal with his legal heir, that is the present respondent.
Yes.
And after issuing notice to the present respondent. Full stop. Till the disposal of the appeal, status quo as of today shall be maintained.
My lord, may I pray that the settlement officer should not be influenced by the judgment passed by the honorable
The
single
settlement officer will proceed afresh, uninfluenced by the observation and merits by the learned single judge. All right.
by the honorable single judge in WPC number 90.
Yeah, that's right. The appeal is disposed of in the above terms.
We clearly list item number 28.
None appears as is not possible.
My lord, item number 28 is kindly infructuous.
Infructuous is disposed of as such. All right.
Item number 29.
Please, Lord. This is against the judgment of the honorable single judge. While stalling the proceeding of a suit, I am the petitioner plaintiff in a suit filed before this sub-judge in a division, claiming right title interest and also for injunction, in which the defendant appeared saying that the conservation proceeding is going on, that is that this is not tenable, it has to be stayed. By filing a petition of 4-4, he prayed for stay, court allowed the petition, and that is how I came to the read forum, and the honorable single judge also appended the same view. Here the facts are like this, you know. My wife has purchased, petitions one wife had purchased a Gharbari land. Status is Gharbari. And during conservation proceeding, the conservation record was in my favor, but the map was incorrect. You know, I have prepared a note, small note. It will be easy for my lord to know the facts. And while that map was found to be incorrect, I filed a revision. In that revision, the matter was remitted back
Ask him to get
to the CO. Matter was remitted back to the CO saying that you correct it, correct the map. CO thereafter said, I have no power because of a decision of the Honorable Orissa High Court full bench. Thereafter, I prefer under revision. In the revision, he said that no, it has to be corrected. So he again remitted back. That was corrected. When that was corrected, the defendant came to file an appeal. In that appeal, that was dismissed because it is bar by limitation. Thereafter, he went in revision. That revision was dismissed for default in the year 2008. When the suit was being proceeded, he filed a petition on the ground that it is pending. But so far as the contents of the plaintiff is concerned, it is not pending. There is no stay. Since your petition to restore it, it has been dismissed for default and you are awaiting restoration, that will not deem that the case is pending or the constitutional proceeding is still on. I had also once came to this whole court in earlier, where after dismissal of his petition for restoration, the court again restored it, to which I challenged, saying that how he has restored the case because certain petitions were pending which were not adjudicated. Despite that, he has simply by one pen stroke saying that yes, it is restored. This honorable court said that no, this order is bad in law. Again remitted back, saying that you first dispose of his restoration petition that is pending. And now my suit has been stalled on the ground that there may be a decision conflicting which may give rise to further litigations. But there is nothing to have a conflicting decision, in as much as if he wins, so far as my title over the land is concerned, I have said that it's an easement right which has been prescribed by me, that adversely I am possessing the land. That alternative plea I can take, that can be also established in this case. And so far as this Gharbari land is concerned, there is one decision, 89 CLT 2000, page 333, that so far as Gharbari land, person of the same is concerned, or title is concerned, that is conservation case, has conservation authorities have no power to examine that or to pass any order. It is only the civil court. I pray that the suit may proceed. If I lose, I lose. Since 2008, it is going on.
So this restoration miss case 4 of 2010,
My lord,
it's not been
That has not
disposed
been-
of for the last
that is
12
still
years.
pending, still pending, because he is buying out time. The tactics is how to buy out time. You
What
not
is the
give-
suit about that you have not told us at all? Why have you filed the suit?
Suit about that has been discussed at the first page. My lord, may kindly see page 9 of my writ appeal.
You
I-
tell us. You tell us. What is the suit about?
Suit is to declare my title over a city land. Suit is to
That you have not mentioned in this note at all.
that
What
has
is
been
your suit you have not
clearly
mentioned?
mentioned in at page 9, my lord. That is why I am not.
No. In your registered sale deed, there is some description of land. Your wife
have
purchased.
annexed the plan.
Your wife purchased the suit
Yeah.
land, correct?
Madam, kindly bear with me. I have annexed the plant before the Honorable Single Judge. In plant, everything is there, and that has been reflected in the impugned order, my lord. Kindly see that.
No. If we have to, you want to explain in your own words, or you want us to read?
No, your lordship must read. I cannot.
You cannot assist. All right. Only we have to do it.
My
You will only place documents we have to read.
lord, read appeal is next.
Yeah. We will read everything, sir. In your own words, can you answer is what we are asking.
I thought it proper that I should not file.
Not
again.
say anything at all.
It is-
Only judges should read it. You should not say anything.
I'm just reading. What
No,
is-
don't read. If you have to read, we will read. You are appearing with the other side.
Okay.
You explain. You explain.
My lords, your lordship, they have in the suit their the relief sought are with declaration of right title and interest, and in the proceedings pending before the consolidation commissioner, these rights are only going to be decided, my lords. And I don't have instruction what is the present status of the miscase, my lord. That is the fact. But before the consolidation commissioner, these rights are only being and the statute also says that the civil court jurisdiction is barred if these the right.
No,
rights
on
are-
Gharbari land, it cannot. There is a clear decision. Homestead land, they have got no jurisdiction. If title is claimed, that is 2000 CLT, volume 89.
See, it starts with suit in
Page
2001.
334,
Consolidation was done in all respects in 1984 itself.
Page 340.
It started much earlier. See, you filed a suit much later.
I filed a suit.
Much
when
later, after the
revision-
consolidation proceedings were going on, revisions were filed, matter was remitted back. After that, you suddenly one fine day you woke up and you said, "I'll file a suit now."
No. My
You filed a suit in 2001. These consolidation matters have been going on since long, sir.
In
Your consolidation revision case was filed in 1984.
in
You
2000
yourself filed the consolidation revision case in 84.
In 2001, I filed this suit.
How
When
suddenly one fine day you filed a suit?
I filed a suit because he disturbed.
Sorry?
Because he disturbed over my position. So I just
No, you can't.
defendant
That
disturbed
very
my
issue is
position.
pending in consolidation proceedings. You can't file a civil suit.
By the time I filed this suit, consolidation proceeding was over 41.
No, your revision case was
made.
pending, sir.
You
Your
know?
revision case 1879 of 84 was pending before the Commission of Correction of Map.
That was adjudicated,
No, it was remitted back.
remitted back.
So it is
After
not over yet.
that was not over then. Then I filed a suit.
That's
Because
what the suit
it-
could not have been filed
It
when these
relates,
consolidation proceedings are going on.
because it relates to homestead land. Well, I appreciate that decision. 89, volume 89, 2000 CLT, they cannot recite right title in respect of a gharwari or homestead land. That is the
So
decision
this
of
is the correct order that the single judge has passed. Ultimately, if the consolidation revision petition preferred by the defendant is dismissed or not restored, suit will revive. That's correct order.
As your lordship, this is my case.
All right. The challenge in the present appeal is to an order dated 6th December to September 2012, passed by the learned single judge, disposing of writ petition civil 15002 of 2012, filed by the present petitioner, present appellant.
Just make a mention. Let there be direction that he will cooperate in the restoration matter. He's delaying the matter, it is not being heard as yet. Only that prayer may be considered.
The grievance of the present appellants before the learned single judge. The challenge by the appellants before the learned single judge was to an order passed by the trial court by the civil judge junior division Bhubaneswar in an application filed by the respondent defendant in CS number 210 of 2001, filed by the present petitioners, present appellants. To the effect that further proceedings in the suit will remain stayed pending the disposal of the pending proceedings under the Orissa consolidation of holdings and PFL is what? And Prevention of Fragmentation of Lands Act 1972, Bracket Act, paragraph. It must be recalled here, it must be noted here that the aforementioned suit was filed by the present appellants, as plaintiffs, for declaratory reliefs in respect of a property which has now been recorded under consolidation khata number 1003 plot 4316 way back in 1984. With the publication of a notification under section 41 of the aforementioned act, claiming that the wife of appellant number 1 had purchased the suit land under a registered sale deed of 17th July 1967. The aforementioned suit was filed in 2001 during the pendency of the consolidation proceedings. First of admittedly, stage at which the proceedings are pending under the Act is to consider the correctness of an order dated 31st May 2002, passed by the consolidation officer, ordering correction of the map pertaining to the plot in question. Apparently agreed by that order. The respondent herein went in appeal before the deputy director, which came to be dismissed on the ground of limitation on 23rd December 2003. The revision petition filed by the respondent, being revision case number 1 of 2004, was apparently dismissed for default on 2nd July 2008. A restoration petition filed by the defendant came to be allowed, and against that order, the present appellants filed writ petition civil 10056 of 2011, in which an order was passed by this court remitting the matter to the commissioner to pass a fresh order in restoration miss case 4 of 2010 paragraph. When this court inquired from learned counsel for the appellants as well as the respondent about the present status of the aforementioned restoration miss case, counsel to the appellant states that it is still pending before the commissioner, whereas counsel to the respondent is not aware of the present status. Paragraph. In any event, the court notes that in the impugned order, the learned single judge correctly noted that once proceedings are pending in respect of the same land before the authorities under the Act, it would not be prudent to allow the suit to proceed, since obviously the possibility of conflicting decisions being given by in the two parallel proceedings could not be ruled out. The learned single judge has therefore correctly observed open quotations. If ultimately the consolidation revision preferred by the defendant is dismissed or not restored, the suit will revive and shall continue. Unquote. In other words, the learned single judge has declined to interfere with the order of the trial court. Paragraph. Having heard learned counsel of the parties, the court is unable to come to a different conclusion
Well, that observation
from that of the learned single judge. Full stop. No part of the order of the learned single judge calls for interference. The writ appeal is accordingly dismissed.
in that restoration matter, he should cooperate or take steps.
It will be open to the parties to approach the commissioner to take up the restoration case expeditiously and dispose it off as early as possible.
Right.
Weekly list item 30.
None appears dismissed for non-prosecution.
Weekly list item 31.
None appears dismissed for non-prosecution.
Weekly list item 32.
None appears dismissed for non-prosecution.
Item 33.
33, your lordships, no, lordships,
Yes.
Your lordships, may you just kindly look at page 23 of the brief.
Yes.
Lordship, this is a matter where NALCO disputed the claim which was raised by ASI for a certain contribution on the ground that they have no facilities there, and also that they have been paying 4.7. They have a contract with the contract laborers to pay 4.75 of their wages. In view of this, there was a lot of show causes which were made, and prosecution also initiated, and there was a writ filed for the single bench. And you'll also look at para 8 of the single bench order. Mr. P.P. Ray, learned counsel appearing on behalf of opposite party ASI Corporation, challenges the maintainability of the writ petition on the ground that in the writ petition only the show cause notices have been challenged, and at this stage this court should not interfere.
Yeah, that's correct.
Your Lordships, that point has been dealt. Your
By
Lordship,
now it should have become infructuous. There is no stay in the appeal.
Your Lordships, now we have filed an appeal under Section 75, and it is a statutory pre-deposit which we have given. Statutory pre-deposit, and
So why should we? What is wrong with the single judge's order?
Only mistake with the single judge we think is made is that if it wanted to dismiss the matter on the threshold, should not have gone into the merits. It has given all the merit finding. So we just want that the
all right. You say the
affected
All right. The appellant had approached the learned single judge against a show cause notice issued by the ESI Corporation. We'll stop on the short ground that at the stage of show cause notice, there was no case made out for interference. The learned single judge has declined to interfere and dismiss the writ petition. We'll stop. In the meanwhile, in the present writ appeal, no order has been passed by this court thus far. We'll stop. Counsel for the appellant informs the court that against the order in the show cause notice, adjudication order in the show cause notice, an appeal has been filed and is pending before the appellate authority under the ESI Act. We'll stop. The only clarification sought is that no observation of the learned single judge on merits in the dispute order will influence the appellate authority while considering the appeal. We'll stop. It is clear that whatever observations are made by the learned single judge on merits in the impugn order were not meant to be conclusive, since the adjudication of the show cause notice had not yet taken place. Paragraph. Consequently, while clarifying that no observation on merits by the learned single judge would influence the appellate authority dealing with the petitioner's appeal under the ESI Act, the appeal is disposed of.
Lordships, there is another appeal also 408. That's not on board. Your Lordship, same order can be passed.
All right. On mentioning it's taken on board 408, in view of the order passed today in writ appeal 407 of 2012, the present appeal is disposed of in the same terms. Correct.
Weekly list item 34.
Lordship, the filings of judgments directly cover the issue. Lordship, I challenge the impugn order, page number 13 of the annexure 1, your Lordship. That is the conciliation officer. The section 33 to be application has been preferred before the learned conciliation officer. You will also have a glance to 2008 7 SCC 594.
So you have to first tell us facts. You're only talking about judgments and orders.
File the date chart, your Lordship. On 4/6/2006, a charge sheet has been issued. Also on ground of forging of taking two bank loans. Also on 9/10/2006, he has admitted the charges and beg apology. Also, that is page number 20. Also has a glance to page number 20. May I read on?
Addressee left. Requested not received. Speed post. No. That was afterwards. Paper publication. without taking confirmed details. For the opposite party number 2.
My lord.
Who's appearing for him?
I'm appearing, but I don't have any instruction, my lords. And in the noting also, it is stated there.
How old is this workman?
Your Lordship,
He's an accountant.
56 years, 54 to 56 years.
Where is page 3? You have page 3? Oh, 3 is mean put earlier there. All right. The inquiry is completed ex parte.
The Lordship, as per the settled position of law, when he has admitted the charges, there is no inquiry is required.
Where's the question of admission of charges, sir?
Lordship has a glance to what are the charges your Lordship has. Lordship has a glance to page number 20.
Yes.
I have filed the type copy, your Lordship, to the senior manager. Sir, with due
So
regards,
this all has to be proved, sir. We don't know what circumstances he gave this letter. It has to be proved in an inquiry.
No, sir, before the that is my whole submission, your Lordship. Your Lordship has a glance to reported judgment of
So without notice to him, you hold an ex parte inquiry and you find him guilty of the charges. Come to your date chart, page 311, 1st November 2008.
Subsequently, during the appeal period, your Lordship.
That's right. You hold an inquiry while the conciliation proceedings are going on.
My respectful submission is the Lordship that I have assailed the order under Annexure 1.
So that order is only disapproval because of 33(2)(b).
He has no authority. My due respect, your Lordship, with due respect, as per the judgment of the Honorable Appeals Court, also ruling made by this Honorable Court, he has no authority at all because Section 12 has, under the Section 12 of the ID Act, he has authorized to inquire the matter. Under Section 12(4) of the ID Act,
who filed this 33(2)(b) application?
The management has been filed, your Lordship.
Why did you file it?
Because due to pendency of the...
No, if you say he has no authority, you shouldn't have gone before him with an application like this.
He has no authority to adjudicate. Your Lordship has a glance to the...
Just see the Industrial Disputes Act.
Your Lordship.
Let's see 33(2)(b). So it's also during the pendency of conciliation proceeding.
Your Lordship,
So you rightly filed an application before the conciliation officer.
right. Your Lordship, agree with. Your Lordship has a glance to two paragraphs only 6 lines I want to show. A 2008 Supreme Court 250, same judgment 2008 7 SCC 594. Your Lordship has a glance to para number 6 and 7. That is the 2 lines only, 2 small paragraphs. May I read you?
Yes.
The Honorable High Court failed to appreciate that in terms of Section 33A for not obtaining permission of the conciliation officer under Section 33, the only legal consequence provided is that the conciliation officer shall take the complaint of contravention of the provision of Section 33 into account in mediating in and promoting the settlement of such industrial dispute. Therefore, next paragraph. The conciliation officer, unlike the labor court or industrial tribunal, has no power of adjudication. Therefore, he cannot set aside the order of dismissal.
That is a very different thing, sir. Even the para 6 doesn't apply in your case. In that case, not obtaining permission under Section 33, the legal consequence was being spelled out.
My lord. Lordship has a glance to
No, but here we are not reached that stage.
Kindly for one line, your Lordship. Only allow me one line. Next page, your Lordship. First line, under. What is the scope and power of the conciliation officer? Under Section 12(3), if the settlement is arrived at during conciliation proceeding, a report is to be sent to the by the conciliation officer to the government together with the settlement.
So why are you challenging? You are the one challenging the refusal of permission.
My lord.
Now you say it is of no consequence.
Well,
having challenged it, then you are acknowledging there is a consequence.
No, Lordship, he has no power to adjudicate.
Then he is not adjudicating dismissal.
He has no authority. You Lordship has our own High Court judgment.
So you are not listening.
My lord.
You are not listening carefully. That's the whole problem, sir. You are full of your own argument. Now come to this judgment you are reading.
My lord.
Para 6 is what you are reading to say para 7, correct?
My lord.
Conciliation officer has no power of adjudication. Come to para 7.
My lord.
Therefore, he cannot set aside the order of dismissal. What is challenged before a conciliation officer is not a dismissal order, even in this case. He is not adjudicated on the dismissal. You filed an application before him under 33(2)(b). That 33(2)(b) is only for permission to proceed. On that, he says yes or no. He's not adjudicating the dismissal. So you're completely misconceived in your argument that somehow he has decided the correctness of your dismissal. He has not.
No.
You asked him for permission under 33(2)(b). He has said, no, I'm not giving you permission. So that's the end of the matter.
So Lordship has another judgment of our own High Court. Lordship has a glance, kindly glance. Lordship pass any order. I have no objection. Lordship, no.
So you're arguing as if we are refusing to read anything that you're giving us.
No, I am placing you.
We are actually not only reading, we are putting questions to you on what you have given us.
No.
Why are you arguing as if we are not prepared to do anything? We are not prepared to read you. We are not prepared to read any document you're giving.
Sorry, I have not. Lordship has a glance to order passed by this own High Court. Same authority, same management, only the persons are different, your Lordship. Identical matter that has been returned back to the conciliation officer.
No, how many times? This time, once already that is over. In your own list of dates, once this court set aside, send it back to the conciliation officer. That has already happened.
The charges are regarding your Lordship.
You're going on, since you have enormous litigating capacity, sir, you're going on filing every petition after petition.
The conduct of the opposite part number 2 may be seen, your Lordship.
Absolutely nothing. Yes. 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 Yeah. In fact, he will now file an industrial dispute if he is so inclined. This court has heard.
Two civil suits have been filed by the respective banks for the alleged fraud. 2 civil suits are pending before the.
So we are not going to comment on that at all. The scope of the present writ petition is very narrow.
My lord.
You say aggrieved by an order passed by the conciliation officer, Assistant Labour Commissioner Bhubaneswar, rejecting its application under Section 33(2)(b) of the Industrial Disputes Act 1947 by the impugned order dated 2nd March 2012. the present writ petition has been filed. Full stop. Filed by the management, that is Messrs. Orissa Power Generation Corporation Limited. Full stop. While directing notice to issue in this present petition on 4th April 2012, the operation of the impunity of that stay order is continued for over 10 years now. Paragraph. The opposite party number 2 was charge sheeted by the management on 4th June 2006 on the ground that he had availed personal loans by forging the signature of the DDO of the management, and also ensured that the management became guarantor for such loan. Full stop. Contending that the opposite party number 2 had in his reply to the charge sheet admitted to the charges and undertook to repay the loan, the management decided not to hold any disciplinary inquiry and simply issued a second show cause notice proposing punishment of dismissal from service. Full stop. On 4th October 2008, a notice of inquiry was issued in which the opposite party number 2 employee appeared and submitted that he could not participate in it unless the employer-employee relationship is restored. Full stop. Admittedly, that inquiry was completed ex parte, finding the opposite party number 2 guilty of the charges. Full stop. Paragraph. At that stage, it appears that on 2nd March, it appears that the management on its own filed an application under section 33 bracket 2 bracket small b of the ID Act before the CO cum ALC. For approval of the action taken by it. Full stop. Council, it is this application that has been rejected by the impugned order dated 2nd March 2012. it must be mentioned here that this is the second round of litigation before the High Court. In the first round, the management's application filed before the CEO come ALC was rejected by the CEO on 23rd June 2007. That was challenged by the management by filing writ petition civil 8133 of 2007. Full stop. This court disposed of the writ petition on 30th April 2010 and remanded the matter to the CEO for a fresh inquiry and to decide it in accordance with law. Full stop. In the meanwhile, it appears that the management changed its mind about not holding an inquiry and decided to appoint a subcommittee to inquire into the charges and issued notice to the opposite party number 2 workmen. Full stop. It is at that stage that the workmen declined to participate. Then counsel for the, you say the in the impugned order, after noticing all of the above facts, the CEO has proceeded to decline the
problem
under section 32 bracket B of the ID Act. After noticing that what is the pending industrial dispute? Why did you go to 33(2)B? Where's your application to 33(2)B? Do you have a copy of your application under 33(2)B?
My lord, I have annexed that.
Yeah, page 25.
Annexure 7.
My lord.
Let's see that.
A chapter of demand was put.
That's right.
My lord.
The union has, that's right. You see, it's a concept of the petitioner has relied on the judgment of the Supreme Court in management Essot Mills Limited versus presiding officer Labor Court. AIR 2008 C2504 to urge that the CEO had no jurisdiction to adjudicate the correctness of the order of dismissal, and that notwithstanding that there may be a contravention of the provisions of section 33, it would not affect the order of dismissal. Paragraph in the present case, with the management itself having invoked section 33(2)B of the ID Act and gone before the CEO, a question of failure to adhere to the said provision does not arise. Full stop. Secondly, it is seen here that the invitation to the CEO to even comment on the order of dismissal is only because of the management insisting that he should rehear the application on merits. Full stop. A short point before the CEO was whether the action of the management in dismissing the workman on 7/5/2007 without seeking the approval of the CEO under section 33(2)(b was justified. Full stop. On its own, the management decided to hold an inquiry, therefore tacitly admitting that the earlier dismissal order was unsustainable in law. Full stop. It is for this reason that the CEO has noted the above legal effect of the management itself proceeding to hold an inquiry. Paragraph. The court therefore is unable to find any error having been committed by the CEO in declining the permission under section 33(2)(b), bracket small b of the ID Act. So the legal consequence of such rejection of the application would only mean that the inquiry would have to be held afresh after proper notice to the opposite party number 2 workman. Full stop. With the management itself having arrived at that position on its own during the pendency of the proceedings before the CEO, it is only logical that it should proceed now to do so in accordance with law. Full stop. In other words, notwithstanding the ex parte dismissal order, ex parte completion of the inquiry, it will be open to the petition management to conduct the inquiry afresh in accordance with law. The court finds, therefore, no reason to interfere with the impugned order of the CEO. The petition is accordingly dismissed. Okay.
Weekly list item 35.
There is a IA, my lords, for substitution of the legal S. That's on record at flag C. So that may be allowed. This is relating to a Khasmal lease wherein a renewal has been rejected under Annexure 7. On some merits, I'll just show my lords what is that. We have given a short list of dates today, my lords. Annexure 7 is under challenge. May I just quickly run through the list of dates?
Yes.
4/10/1934, the collector Baleswar on behalf of the secretary and the state of India in council executed a registered lease deed in favor of one Benudhar Mahanti in respect of a Khasmal land in Baleswar town so and so for acre 0.04 and half decimals. Plot numbers have been mentioned. The petitioner occupies an area of 0.55 decimals from an area of so and so. This is important. Clause 14 of the agreement of lease provides that the lessee shall be entitled to renewal of Khasmal lease by making an application to the collector 3 months prior to the expiry of the lease, subject to due observance of terms and conditions. The lease deed has been annexed under Annexure 1. Now, 6/10/1947, Benudhar Mahanti alienated the land in question in favor of Kishori Mohan Mahanti. That is also annexed, Annexure 2. 8/5/1950. This is a second renewal, my lords, Annexure 3. Then, my lords, 23/11/1968. This is a case of third renewal. 5/1/1982, Annexure 5.
further renewed, my lords. Same clause numbers change. And then 1910-93, the petitioner submits an application for renewal. That is kept pending. Then, my lords, OJC 8854 of 2001, the inaction for disposal of renewal, that was challenged, and that was disposed of on 23/12/2011. Then on 26/3/2012, Annexure 7 has been passed. Now, so
what's the ground of rejection?
Ground of rejection is that there is no material to show.
It's a Khas Mahal land.
It is a Khas Mahal land. Now,
What
my
is
lord,
Khas Mahal?
voluminous documents to show that it's Khas Mahal. My lord, may kindly see Annexure 1 itself.
No, so it should go back for a fresh decision. Is that what you're asking?
So the order, my lords, is palpably illegal. Now, if we see the tenor of judgments of this court, they have all along protected the rights of these Khas Mahal lands.
What are Khas Mahal? I'm not clear.
Khas Mahal, my lords, is private property. Now, in fact, in Cuttack, if my lord sees Cantonment Road, where that area, that even till Sheikh Bazar, all that, most of these lands are Khas Mahal lands. Now, recent judgment of this court,
what do you have there? A residential house?
Residential house. We have constructed on that, and the terms are specific. If you need it for public purpose, then you have to resume it.
Correct.
So you give compensation and take it back.
Correct.
No,
So-
my lord, what I beg to say.
No, just let me complete. Now, my lord, may kindly see the terms, my lords. The terms of the renewal clauses from 1934, what has happened? My lord, may kindly see Annexure 1, my lords.
No. The rejection now is because it's not Khas Mahal.
Rejection is because it's not Khas Mahal. Now, right
How does he justify the earlier renewals then?
he says that it is a palpable mistake.
Ah,
Now, from 1934 onwards, this mistake has been continuing, my lords. My lord, may kindly see Annexure 1, page 12. The heading itself is Sri Kanthapur Khas Mahal land in town, so and so. At page 12, I am reading, my lords.
yes.
Now, the relevant renewal clause would be at page 16, clause 14. If 3 months prior to the expiration of the said term, lessee shall notify to the collector that he is desirous of taking a new lease, so and so shall have duly observed and performed all the terms and conditions aforesaid, and he shall be entitled.
No, is there any schedule to the lease deed which says it's Khas Mahal? Or it's only the first line of this lease deed?
No, it is first line, my lords. Then we have been paying rent. Those rent receipts are there under Annexure 10 series.
So that's what I'm saying. So it's typed on top, Sri Kanthapur Khas Mahal land.
Correct, my lords.
And this indenture is made by the Secretary of State of India and Council.
Correct.
So it's been always described as Khas Mahal.
Yes, and renewal also thereafter, the second renewal, third
So
renewal.
let's see the impugned order and let's try and understand
My
why he's saying it's not Khas Mahal.
Annexure 7 at page 38. They quote the order of the High Court in so and so. There, the High Court says that you decide in terms of these judgments, Prafulla Republic of India versus Prafulla Samal, so and so, and keeping in mind the amendment to Section 4A and 3 of the OGLS Act. That is quoted, my lords. So after quoting that portion of the order of this honorable court, the court records a copy of the petitions dated of the petitioner is available on record. The contentions speak as below. And then he records that. In addition to the above, at page 39, I am placing, in addition to the above contention in course of hearing as well as in written synopsis, learned advocate for the petitioner submitted that the fact that the land is Khas Mahal land has been admitted by the state in lease agreement as well as receipts granted by the state. In support of the fact that disputed land is Khas Mahal, the learned advocate for the petitioner relied on the dictionary meaning of Khas Mahal scripted in Ajanta Oriya Dictionary and Taruna Sabdakosha Further submission of learned advocate for the petition is that the Union of India is the owner of the disputed land and therefore lease subsequently cannot be altered except under the sanction of the RDC. Thus, learned advocate for the petitioner summed up his submission with the prayer to pass an order directing the Tahsildar to settle the case line in the name of the petitioner. First of all, it needs determination if the disputed land was / Khasmal land or not. This is the core issue as it comes out from the submission of the learned advocate for the petitioner as well as
No,
the
but how can
contents.
you produce? I don't understand. The doubt is being raised by him,
By him.
but he says you should now prove that it is it has the characteristics of Khasmal. After
Yes.
1934, how can that be proved?
And my lords, rent receipts have been given annexure 10 series, which have been filed by way of additional affidavit, where rent has been accepted and there also it is mentioned as Khasmal. So all renewals mention Khasmal. The nature is such. Khasmal has this order that you are entitled to, the renewal is mandatory. And if you want to take it back, then you have to follow the process. Now, my lord, may kindly see the order itself on the face of it is not tenable. Tahsildar Baleswar.
Only the last paragraph, I don't know where he gets, page 39, last paragraph. As per CS record.
As per CS record, the classification of land was Nayanjori.
Which land is he talking about? This very land.
Suit land.
No, but where does he get this? Where is the CS record which shows the classification to be Nayanjori?
That is the Tahsildar's report.
Where do you get that?
Letter number 963 dated 3/2/2012.
The contention of the report.
No, the report is silent if the land had the characteristics of Khasmal. So it's only silent.
And then next line, learned advocate for the petitioner has not produced any paper proof.
And then this also says, speaks that the land having Kisam Nayanjodi does have the characteristic of Khasmal. Does. If it does have the characteristic of Khasmal, what's the problem?
No paper is.
No paper proof has been produced.
No. The last, just see this, as per CS record, the classification of the land was Nayanjodi. Common sense speaks. The land having Kisam Nayanjodi does have the characteristic of Khasmal.
Does have.
So after saying it does have the characteristic of Khasmal, he just turns around and says there's no proof. Never having. He's contradicting himself.
My lord, may I be permitted to
Yes.
to my learned friend's permission? Your lordship may kindly have a glance on the lease deed itself. What are the conditions? That is at page 14. First lease deed I'm taking your lordships. At page 7. What he is saying that I have, it is a nali and it is adjacent to the house. The lessee shall not erect any building. I'm reading page 14, paragraph 7. Make any addition, any alteration or demolition, remove any building.
No. If you're reading, you read from page 12.
Page 12.
And read the first typed line.
No, bereft of that characteristics of the land.
No.
Your lordship has rightly pointed out.
This is not something his predecessors written. This is written up by the government of India, the Secretary of State.
Yes, ma'am.
It's a typed document.
Yes, ma'am.
It's not something that he has created.
No. Lease was granted. That is
no. First line. How can you ignore the first line?
Secretary of State of India.
No. Above that's a title.
Srikanthapur Khasmal land in town Bhaleswar.
This is not typed. This is a typed document.
Yes, that is there.
It is not that one fine day he woke up and he started calling it Khasmal. When he was given the lease, he was told this is Khasmal land.
Yes.
And then every renewal is granted to him without raising any such objection.
My lord, so far as these characteristics of the land is concerned, now we are finding certain infirmities in the impugned order.
So when do you wake up to it? The problem is this. From 1934.
Because it is recorded in PWD. That is also that it is a PWD land. It was originally an Anavadi land. It was a government land.
So now he has a house. So since 1934, he has got it.
Yes, that your lordship can ask me that question. Then how do you granted the lease to a private individual?
And renewal, first renewal, second renewal, third renewal. How do you keep on granting renewals?
That is the
one fine day after some 80 years, you say no. Today, I have suddenly realized it is PWD land or something.
Because that was your lordship may kindly have a eye over this particular field position.
What is the extent of this? There's some
45
point
decimal.
0.5,
No, no,
0.055 decimal.
If 1000 decimal is there, then one gunt as per Katak. That is around, let us say 2000 square feet.
What is that for?
No, that is not because it is left for what that the
So you
collector
acquire
has.
it. If you need the land, you acquire it.
No, question of acquisition is not because they are not. That is what I wanted to show your lordship. They are not permitted to make any construction over that.
When did they make the construction? When did you wake up to this fact?
There is no. There is no material on record that they have sought for permission from the lessor to make construction. Now he is saying that there is a house over it.
No, he has just come to you for renewal of lease. It is not that you issued him a show cause notice and then he has to defend it. Not like that. You have been approached only for renewal of lease, and today finally you say that this is not Khas Mahal land. That's why I'm not renewing the lease.
It is now recorded. Currently, it is recorded in favor of PWD department. That is Works department by the settlement authority. Because there is no renewal of the lease, and the collector has rejected the renewal, and I was also looking to the file. I think there is no interim order passed.
No, there is.
Right from day one.
Stay of operation.
I'm sorry.
First order is 2nd May 2012. Stay
That has been continued from time to time.
Yes.
There has been an request to
Lordship may
produce the
direct the
record.
collector to reconsider this aspect.
No, why go back and forth? I don't know.
No, it is a case.
There is one judgment
because,
I have.
And another thing is that the recorded owner is not hard. Recorded owner is the PWD department. Currently,
that
the
is a matter of record of right.
Sale deed, sir.
Yes, that is admitted fact. I have annexed A/1 in my counter affidavit. Your lordship may kindly have. Purto Vibhago is the recorded owner. This file is also with me. I can produce before your lordship. Purto Vibhago, that is the Works department, is the recorded owner. Then there is a public.
What is the effect of this registered sale deed then in favor of his father?
That is also, I was searching.
Annexure 2, Annexure 3.
Yes, that is also, there is no liberty granted to the lessee to, but then your lordship will ask me, then how you.
Yes, this is a new case
in favor
that
of the
my
purchasers.
Yes,
that is there. That I cannot improve the case because we have renewed the license in favor of the purchaser. That means we have accepted the
sale deed. Correct.
But my only submission, your lordship will kindly consider that the recorded owner is to be, because there is field difficulties are there. The reality in the field position is that there is a drain over that land. And your lordship may direct the collector to consider these aspects, and after hearing the recorded owner.
He says the residential house there?
No, that is I am disputing.
There is a residential house. The condition of lease.
Then I may be given liberty that to submit a report. Just day before yesterday, your lordship has directed me. Yes, Tahsildar will be.
My lords may direct that. The condition of the lease is that he must construct a building and stay. So now across the bar, he's coming up with this point that he made a construction. That is not their case in the counter, my lords.
That is the lease deed condition.
That I'll make a house, and I have made a house. I'm staying from 1934.
With the permission. That permission you have not.
My lords, I'll say, my lord, what has happened. 1934, this was just a line. Now with efflux of time, the collector suddenly realizes that this has become very valuable. That is the issue, my lords. They feel that why should a small individual get a house at the heart of Baleswar town?
May I submit one thing? Your lordship may direct me. I will submit the field reality report. What is the status? If possible, I will give a video clips on that.
All right.
There has been a series of directions of this court to produce the records. To show that this is non-Jodi.
It is there with me. I can produce it right now.
This is the second round of litigation concerning the petitioner's prayer for renewal of lease of a land admeasuring AC 0.055 decimals in Moza Srikantapur, Baleshwar. Full stop. Earlier, the petitioner had filed OGC number 8854 of 2001 when no decision was taken on his plea for a third renewal of the lease in his favor. Lease in respect to the land in his favor. The said writ petition was disposed of with this court on 23rd December 2011 with directions to the collector to take a decision on the petitioner's application within 3 months. Paragraph. Pursuant thereto, the impugned order dated 26th March 2012 has been passed by the collector, rejecting the petitioner's application on the ground that there was nothing to show that the land in question was single quotes Khas Mahal unquote land, as claimed by the petitioner. Full stop. On 2nd May 2012, while directing notice to issue in the present petition, the impugned order was stayed. Paragraph. During the course of submissions today, Mr. Gautam Mishra and a senior counsel for the petitioner submitted that throughout the land has always been acknowledged as being Khas Mahal land, right from the first lease deed dated 4th October 1934 in favor of the predecessor of the in interest of the petitioner. Full stop. He submits that as of date, there is a residential house that has been constructed on the land in question, and the petitioner is staying there.
Yes.
Paragraph. Mr. D.K. Mantil, an additional government advocate, states that the record of rights reflects the PWD to be the owner
Works
of the
department. Yes, public works.
PWD to be the works department to be the owner of the land in question. Nevertheless, he offers to have a survey done by the Tahsildar Baleshwar and submit a report before the next date on the current status of the land.
Obliged.
And his request list on 19th October.
Interim order to continue.
Yeah.
Yes.
And that
19th October 2022, interim order to continue.
and that IA at Flag C may be allowed. That's implement.
All right.
So that we'll regularize.
And may I request my learned
Flag
friend to
C that
implement
IA
the-
10940, you see,
No, why?
for the reason stated in the application.
May I request that your lordship may direct him to implement executive engineer PWD department
No,
in
that's
this case.
That's all
Because
subsequent.
Ultimately, the land, he is the recorded owner. He is to give some, he is to be heard. That is my,
Well, it's the state of Orissa is a party.
maybe, but.
The RDC
but
is
the-
there.
That is there, but we are revenue departments. They are
It's okay, so only departments are different. You can always
All of them.
represent all of them.
We clearly state
Interim order to continue.
I've said that.
Great. 36. Item number 36.
Wait, please, your lordship.
Yes.
Lordship, in this case, Mr. Ganeshwar Rath, the senior advocate who was appearing, he has expired and I have entered appearance today, your lordship.
All right.
My lords. Your lordship may come to page 8, annexer 1 is the reference, your lordship.
Yes.
Your lordship may kindly have a look at the schedule. Whether the workers numbering 1626 engaged by the contract agencies in different operations like bagging plant, DAP, PAPS, TP, instrumentation, SAP, fire and safety, mechanical, etc. within bracket as per the list to be supplied by the DLO Jagatsinghpur, but who are working in the Paradeep Phosphates Limited, Paradeep, can legally claim to be the employees of management of PPL or not. If not, what they are entitled for wage and other benefits at par with the regular employees or not, doing same and similar work or not. And your lordship knows very well that with regard to the regularization, the matter is covered under the Contract Labor Regulation and Abolition Act, your lordship. But here, your lordship, initially the issue was framed at page 10, your lordship, annexer 2, page 10. As in the schedule of reference, the entire thing has been stated as the issue only, sole issue, only one issue. And thereafter, your lordship, I am aggrieved by the subsequent action of the land tribunal.
Only the number seems to be different.
Minutes?
The reference says 1626 workers.
Yes.
This
It is
issue says 1532.
Your lordship, I must admire your lordship's eyes, your lordship. I have missed that. I'm sorry. Your lordship. Now your lordship sees page 16, your lordship, which is impugned here. Issues have been reframed, your lordship, in pursuance of the order which is at pre-page, that is page 15. Your lordship finds 2/4/2012.
Yes.
Parties are absent. peruse the pleadings of the parties and resettle issues in a separate sheet. Call on so and so for hearing. And it is against this order we are before your lordship. And your lordship sees the next page, page 16, the issues. Now, instead of one issue, there have been now 6 issues, your lordship. And your lordship, this annexer, I mean, issue number 3, the, your lordship is right that number is absent totally in the issue. Number
That's all right. That's
yes,
all right.
yes. But number 3 and number 4, whether the interposition of contractors by the management of first party is a mere reuse or camouflage to evade compliance of various beneficial legislations so as to deprive the workers of the benefits thereunder. This is not a matter under reference, your lordship. And whether the disputed workmen are to be treated as employees of principal employer, that is the first party, and therefore entitled to get their services regularized under the principal employer. This is also not there in the reference, your lordship.
No, let's just 1 minute. Let's read the schedule reference carefully.
Yes, once again, your lordship. Your lordship. Page 8, your lordship.
Yes.
Whether the workers numbering 1626 engaged by the contract agencies in different operations like bagging plant, DAP, PAPS, TP, instrumentation, SAP, fire and safety mechanical, etc., as per the list to be supplied by the DLO Jagatsinghpur, but who are working in the Paradeep Phosphates Limited Paradeep, can legally claim to be the employees of management of PPL or not. If not, whether they are entitled for wage and other benefits at par with the regular employees or not, doing the same or similar kind of work or not. So regularization word is completely absent. And
No. Only thing is in the first itself.
Whether they can be employees of the Paradeep Port Trust.
No. So if they have to be employees, so in the process of addressing the first issue,
yes,
that is persons engaged by the contractors, can they be treated as employees of PPL?
Yes.
That itself presupposes one of the contentions of the workmen.
Yes.
That this contract is only a ruse. Actually, we are working for PPL. So it flows from that itself. So if like you have pleadings in the plaint and then you have written statement, then issues being framed, correct?
Yes.
So likewise, you have a statement of claim, you have the management's reply, written statement, issues are framed.
Yes. Or rejoinder.
Issues don't have to be identical with the reference, but issues can stem from the reference.
Yes.
If you pick up the first issue, whether these are workmen only belonging to the contractors or should they be treated as workmen of PPL?
Yes.
Naturally, unless you find the contract itself to be a ruse, you can't arrive at this conclusion.
And unfortunately, the contractors are not there named in the reference, nor they are party to the case.
Yeah, that's all right. So that we're not concerned about that, what they should do and should not do. We're only on whether these issues are correctly framed or not.
Yes.
So suppose there can be only 2 answers. If they come to if the labor court comes to the conclusion that the contract is a ruse, then it has to treat, the consequence will be they have to be treated even in terms of the reference as employees of PPL.
In accordance with the National Waterfront Workers case, your lordship.
That's right.
Yes, that is, your lordship is correct. But here, your lordship is, there are 2 things I want to point out, your lordship. One is that rule of Orissa Industrial Dispute Rules and the CPC. What is the mode and manner of this settlement? Of
I'm saying, sir, so the only difference would be because 5 is also perfect. 5 also is there in the reference, whether they get the same wages as regular employees.
5 is there. I am nothing to say against 5.
Only 4. You're only agreed by 4.
4 years.
4 is what? Whether she should be treated as employees of PPL.
And
so that getting their service regularized is the only thing which is extra.
Regularized, exactly. That's
the only thing extra. So what turns on that?
That is exactly.
Nothing turns on that.
Nothing
turns on that.
No, Lord. Only if they are regularized only, the consequences follow. Because the other part of the issue number 5 becomes redundant, your lordship.
Correct.
Yeah. Your lordship will appreciate that. Once they are regularized.
Even if you remove that portion, are they entitled to get their service regularized? That's the only objection.
That is the only thing. That is the only thing that.
All right, we can ask him what is wrong with that.
That is the only thing that can be.
Yeah, we'll ask Mr. Mishra. Yes.
I just tell your lordships, neither the statement of claim is filed nor the written statement. We have filed, the workmen have actually filed it by way of a memo.
All right.
And before the
I think
conciliation
no
officer,
questions are
the
there.
report of the conciliation officer categorically notes down everything with regard to the camouflage, everything.
No, maybe
that has been recorded.
We are only on a short
Yes, I
point
understand.
on the issues themselves.
Yes.
So what
With regard to
in issue number
regularization,
4, see
I
if
bow
they-
down to that. I bow down to that.
that can go. Once that goes, he has no objection. It can at least
bring to your lordship's knowledge. If your lordship will go to page 16, the issues, as far as the first issue is concerned,
he's not objected to that.
No, I'll just tell your lordships because I just wanted to inform your lordships because that won't come as a bar to me because I have filed an application to delete this issue in terms of the judgment of the Supreme Court, where the Supreme Court has held that the
but that is not the subject matter here.
Not a subject matter here.
So let's not enter into that.
Actually, my application is listed before the tribunal on the 25th of August.
That's right. Whenever that is taken up, you can deal with that.
Yes.
So we are only now on the 4th issue, on the second part, whether they're therefore entitled. That can go.
Those person only go. Yes.
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 That's only the portion entitled to get their services regularized under the principle.
Exactly. Exactly. Only that.
Very well.
All right. A very short a very short question arises for determination in the presented petition by the management. By Paradeep Phosphates Limited bracket PPL, arising from an order dated 2nd April 2012 of the Industrial Tribunal, Bhubaneswar, framing issues in ID case number 27 of 2001. Paragraph. The background to the present petition is that by an order dated 3rd December 2001, the Labour and Employment Department of the Government of Orissa
I'm sorry,
referred
it is 13th December.
13th December, all right, referred the following dispute to the tribunal for adjudication. Reproduce the whole of the schedule in page 8, paragraph. After the statement of claim was filed by the workers' union, and a written statement was filed by the management in response thereto. By the impugned order dated 2nd April 2012, the tribunal framed the following issues in ID case number 27 of 2001. Reproduce the whole of page 16, the 6 questions. Paragraph. Mr. N.K. Mistral and senior counsel appearing for the petitioner raises an objection as far as issue number 4 above is concerned, to the extent that it envisages a situation where if the workmen are to be treated as employees of PPL, whether they would be open quotation entitled to get their services regularized, question mark, unquote. Regularized, unquote, under PPL, question mark, paragraph. Mr. Mishra points out that the original term of reference had made no mention of any issue concerning single quotes regularization, unquote, of the workmen, and that too under PPL. Paragraph. Mr. Subhashish Mishra and counsel appearing for the workers' union is unable to dispute the fact that the reference as made to the tribunal makes no mention of any issue concerning regularizing of the services of the workmen under PPL. Full stop. The first part of the reference itself envisages that if the workmen, either of two situations, one, the workmen being engaged by the contractors, or the workmen actually being employees of PPL. Full stop. Consequently, issue number 4, as framed by the tribunal, by its order dated 2nd April 2012 is modified and will read as under, open quotation, whether the disputed workmen are to be treated as employees of principal employer, that is the first party, unquote, question mark, unquote. With the above modification, the writ petition is disposed of, the interim order stands vacated.
Very good.
All right.
Grateful, Your Lordship. I'm happy to see that Mr. Mishra is back, Your Lordship.
All right.
Weekly list item 37. Item 37.
নম্বরটা ঠিক লিখে দিও।
None appears to system of us.
Weekly list item 38.
Consider petitioner seeks leave to withdraw this petition. Dismisses. The memo is taken under copy.
Weekly list item 39.
To give a liberty to approach the appropriate authority with regard to resettlement.
All right, council petitioner seeks leave to withdraw this petition with liberty to approach the appropriate authority in accordance with law.
Okay.
Dismisses withdrawn with liberty spirit. All right.
Item 39.
The matter has become infructuous.
No, that has become.
All right. Council petitioner states that the matter has become infructuous. Is disposed of as such.
Weekly list item 40.
None appears to system of us.
Weekly list item 41.
My 40. I'm for 40.
40.
Yes.
My lord, the sole point in this case that the lessee in the Westland case has not been noticed, but the lease has been cancelled.
What was the date of your purchase?
My lord, I've given the chart. On 24/7/73, the lease was granted. Quota was issued on 14/8/7.
Sell deed given. Sell deed of 2009.
And when was it cancelled?
No, it was the cancelled in 2003.
So it was purchased after cancellation.
No, my lord, one thing. The original lessee was not noticed.
That's okay. That's
He is
the
not
original lessee has to come.
He is not.
You don't have local.
No, he has made party in this case.
No,
I have been affected by that because my lord only have a look at page 66. 66 read picture. 21/8/2002 order. 21/8/2002. Here put up notice was not served yet. Hearing date posted to 5/9/2002. 5/9/2000. Here it put up the lessee is absent. Fixed to
What rest page 66?
After that it was
Last page is 60.
And after that, this Prasanna Kumar Das, who was a original lessee, has transferred the land on 23/5/89. And he's a party also. He's my vendor. So my humble submission, if they were not noticed and lease has been cancelled, indirectly I have been affected. My only grievance to hear the lessee or his purchaser in the case. Nobody has
still around. We don't even know if these vendors are still around. Are your vendors still around?
All are there. I have made them party.
No, making them party. Are they around? Meaning, are they represented here? You can make anyone party, sir.
I have made party this Surjanarayan Patnaik and Anjalika Patnaik 4/5 and Prasanna Kumar Das, the original lessee.
What is his age?
My lord?
What is the age of the original lessee? OP number 6.
Prasanna Kumar Das, perhaps he is no more.
He's there.
Oh, who says he's there? Who's representing him?
Yes, he is opposite partner 6.
Oh, 6.
Mr. Das. M.K. Das.
My lord, he will appear.
Only thing is, without expressing any view, let it go back, let them note, issue notice to everybody.
My lord.
All right. The challenge of the present petition is to an order dated
And let me observe that locus standi part will be decided by the.
Now, where is the impugned order? Resuming the lease.
You put on annexure 4, my lord.
Order dated 22nd January 2003, passed by the additional Tahsildar, Bhubaneswar, in WL case number 1079/1973. Resuming the land in Khata number 98, plot number 14, village Krishnanagar, over an area of AC 2.000. Paragraph. The short ground on which the impugned order is assailed by the petitioner is that although the land in question was purchased from the original lessee Prasanna Kumar Das by Suryanarayan Patnaik, Prasanna Kumar Das bracket opposite party number 6, and thereafter sold to Suryanarayan Patnaik and Anjalika Patnaik bracket opposite parties 4 and 5 by a registered deed dated 23rd May 1989, no notice was issued to opposite parties 4 to 6 prior to the cancellation of the resumption of the land in question. So the petitioner herein has purchased the land in question. Is stated to have purchased the land in question on 12th August 2009 from opposite parties 4 and 5 under a registered sale deed. Paragraph. Considering the fact that no notice was issued prior to cancellation of the lease to opposite parties 4 to 6, the impugned order dated (22/1/2003) of the additional Tahsildar Bhubaneswar is hereby set aside, and WL case number 1079 of 1973 will be restored to the said authority, file of the said authority, and will be listed there on 26th September 2022. On that date, the present petitioner, as well as opposite parties 4 to 6, will be present either in person or through their authorized representatives, along with a downloaded copy of this order. Stop. The additional Tahsildar is requested to proceed in the matter after hearing all of them and any other party who may be affected or interested, and dispose of the said WL case within a period of 4 months thereafter. Till such time, the interim order passed by this court on 4th October 2012 shall continue. The petition is disposed of in the above terms.
Weekly list item 41.
None appears disposed on non-passation.
Weekly list item 42.
42, my lord, no instruction.
No instruction is disposed of.
Weekly list item 43.
Item 43, Your Lordship, on behalf of Mrs. Pamirat, we have filed our appearance memo today. Lordship, this is that similar matter covered by your Lordship's judgment by the number 26692 of
Yesterday, one matter was there that was adjourned to 18th of October.
18th of October, your Lordship.
Same order.
47 also
appearing for OP number 2, my lord, UGC.
All right.
47 also same.
47 also same.
47, same order.
But copy may be served to us, my lord. What is
All right.
appearance will
Weekly item 44.
Nana Pistis.
My lord, I'm for the opposite party. My appearance be noted, my lord.
All right.
Weekly list item 45.
Nana Pistis now.
Weekly list item number 46.
Nana Pistis now.
Weekly list item number 48.
Nana.
Opposite part of 5.
All right.
I am for the opposite of 5. My present frame of
All right. Nana Pistis now.
Weekly list item number 49.
Nana Pistis now.
Weekly list item number 50.
50 days, no instructions. No instructions.
Weekly list item 51.
I'm sorry, my lord. 48, my lord, is become infructuous. Item 48. I'm just filing a memo to that effect.
This point.
Item 51.
Nana Pistis now.
Weekly list item 52.
52 on behalf of Mr. Mishra, I prefer an adjournment, my lord. Mr. Manoj.
No.
He's not well, my lord.
All right. What's the matter about, sir? Why didn't you argue?
My lord.
This is all Amruta Manoni land. And in view of Siddhamata's decision, everything will go to the temple trust.
All right. All right. You say Mr. Manoj Mishra is stated to be unwell. Then it's in a constable statement. List on 16th November.
18th November.
16th. Weekly list item 53.
53, madam. May I plead, my lord? Well, this is second round of litigation. In the earlier round, my lord, this onlooker has remitted the matter to the London Labour Court. 53, madam. The Lordship, the first direction of this onlooker at page 50, relevant portion, it starts from annexure 8, my lord. Relevant operating part is paragraph 50, my lord. This court single judge has referring to the judgment of the appeals court and para 10, Lordship page 50. Considering the facts and circumstances of the present case, keeping in view the
only lump sum compensation 1 lakh has been granted in lieu of reinstatement. Nothing else, sir. No reinstatement.
There
is no stay.
No, my lord, no stay.
Only 1 lakh has been given to him in lieu of reinstatement.
But the Lordship see.
No. Have you paid that 1 lakh or you've not paid?
No, I have not paid that.
So you first deposit it here. You're prepared to deposit 1 lakh and you have to give interest from which is the date of the award?
Lordship.
2012. Deposit 1 lakh with interest from 2012 onwards.
May I suggest, my lord, one thing, my lord? If my lord see the evidence of the workman.
We'll see everything, sir. We'll see it threadbare, but you deposit. This is like a money decree. If you have to file a first appeal, will you not deposit?
But here is a case, Lord.
Sir, we will examine merits thoroughly. You can be assured. Neither of us are shirking from reading anything. Every document, every scrap of paper we will read. All right. But you first deposit that 1 lakh together with simple interest from the date of the award.
What is position? And then I have to take instruction.
No.
And because as without
this can't be. You have got simply a stay. You got a stay in 2012.
Stay? No, there is no stay, my lord.
There's no stays. So this is what I'm saying. Since there's no stay, you're obliged to comply with the award. For 10 years, you cannot not comply with an award.
That is not my contention. My contention is that
your contention is not that, sir. We are not on your contention.
But here, my humble what I say.
Sir, we will hear all your submissions. Sir, we will. I know your submission is this award should not be allowed to stand, right? Ultimately, you want us to set aside the award, correct?
That's correct, my lord.
Ah,
Ultimately,
for that,
one line
we are
should
only
be-
telling you, if you want us to do that, you first deposit this amount.
But the workman himself, who is himself a businessman and establishing parallel unit at par with the business rival, my lord, that is own admission.
All right. We'll look into all that, provided you deposit the amount.
I have to take instruction.
No instruction. We can pass it over. You call up your client. Tell us how soon can you deposit?
Lordship, call this matter day after tomorrow, my lord, because I have to take over telephone. Who is
What was he testing in charge?
My lord?
He was a testing in charge. No. What was the designation of this workman?
He was a my lord.
No. I'm just seeing I'm seeing the impugned award, sir.
Yes, my lord. That is, he was functioning at the relevant period. Was testing in charge means, my lord, the transformer electrical unit. He was supervising the technical work of that unit, of the transformer unit, my lord. And he himself has established a similar unit and now running his business. That is the whole problem, man.
You find out, sir. Find out from your client. You can pass it over. You can find out.
Lordship, at least tomorrow, my lord, because I have to take instruction of who is in charge of the over telephone. I have
Find out. We'll pass it over. We'll find out. All right, pass over.
Call this matter tomorrow, my lord, at least.
All right, sir. It's a 2012 matter.
Pass over. Weekly list item 54.
54, no instruction, my lord.
All right.
Lordship, pass it over, my lord.
Yes. No instructions disposed of.
Pardon to mention, my lord. Item 52, my lord, intimated to continue, my lord.
My lordship.
So this is what nothing is happening, sir. Nothing is happening in these matters. Yes.
Item number 55.
My lordship, for item 54, I'm appealing on behalf of opposite party.
All right.
Item 55.
May I plead your lordship? In this case, the petitioner challenged.
55, there are two matters.
In first matter, I am appealing for the petitioner, my lord.
May I place my matter? You lordship may kindly consider the connected matter, that is WPC 2421 of 2012.
Yes. Yes.
Here your lordship may kindly state it down to running page 24. That is the original application filed before the land tribunal.
Yes.
Your lordship may kindly see the cost title at page 26.
Duryodhan Behra, Prashant Kumar Patnaik, Tapani.
These are the applicants. And you also can see the number of respondents. No private respondents were added.
And yet the present petitioner is somebody else.
No. Present petition, yes. No, that's
Madhusudan Pani.
Yes. That because by the impugned order, all those persons who are not parties before the land tribunal, their promotions have been set aside.
Oh, including this petitioner.
Yes.
Oh. Who's appearing for the?
I am the first matter, and I am for the opinion number 426. The applicants in the way.
So you never made these people party.
What happened, my lord? Your lordship should kindly see the page 21 of the impugned judgment. Page 29, paragraph 9. But my prayer was in the way, my lord, that let the DPC for the year 2004, 5, 6 and be held amongst the group D employee in order to promotion to group C. That and it was brought to the notice of the Law and Tribunal, my lord, that while conducting the DPC in the year 2003, my lord, that they have not followed the rules.
No, but you never made these people parties.
My lordship, I have not prayed in that. My lordship, kindly see.
May I submit
paragraph 9.
1 minute.
My lord, paragraph 9. Admittedly, no type test has been prescribed in the OM's method recruitment for post of junior clerks, so rules 1988 as amended in 2001. Rule 11D. And hence respondent 2, that is collector, was not at liberty to go beyond the prescribed rules to impose any additional condition or test. Hence, the typing test is irregular. Moreover, no marks have been awarded for assessment of service records.
So without hearing them, how can these findings be rendered? I don't understand.
But that's true.
But if that's true, then that's
only question is, that was the brought to the what irregularity.
2003.
But
After 8 years, it is
what I
already
want to bring to your lordship's notice is that, but only I want to brought to notice of the London Tribunal that this has been done irregularly in the while conducting the
whatever, sir, since it's going to
But my
affect the
prayer
rights.
was let the DPC be held for the year 2004, 5, 6, and 7.
So without hearing them, no order should have been passed whatsoever. As simple as that.
And they have not followed the rules at all.
And here, in fact,
And
no
there is
relief
no,
has been
in the
granted.
rule itself, the lordship shall kindly see.
We don't have to see the merits on the short ground that these
My lord,
people are
page
not
34. Page 34, relevant page 35. That is 11D. My lord, the Departmental Promotion Committee, while preparing the list of suitable Group D employees for promotion to the post of junior clerk, shall follow the provisions of so and so, so and so. The Departmental Promotion Committee shall take into the consideration the service record of the employees. They have not taken into consideration the service record as admitted by the state respondent, my lord. And only a viable test will be conducted. That's all. And the service past record will be taken into consideration. That has not been taken followed
No relief has been
by
granted
by the state authority.
After
And it is
declared
admitted in the
unsuccessful,
counter also.
after declared unsuccessful in the written test and DPC,
There is no provision for written test.
they have challenged in the year 2007, my lord.
But there
You
is
only
no
send it
provision for
back.
written stroke and as
They're
well as
only
the
going to
type
send
test.
it back. You make them parties, let them everybody be heard. You say both these writ petitions, a sale and order dated 20th June 2011, passed by the Orissa Administrative Tribunal in OA number 2787 of 2007. While the state has filed writ petition civil 2421 of 2012, the affected private parties, who were not included in the said OA, have filed 22148 of 2012. Paragraph. While issuing notice in 2412 of 2012, 2421 of 2012, this court stayed by the order dated 21st November 2012, the impugned order of the OIT. So that in that view of the matter, no separate interim order was passed in the companion writ petition 22148 of 2012 while issuing notice therein on 12th March 2014. Paragraph. Counsel appearing for the original applicants before the OAT, who have all been included in the present writ petitions, is unable to dispute the fact that the petitioners in 22148 of 2012 were the real affected parties and they were not included in before the OAT. Stop. He ever sought to urge that the prayer in the aforementioned rulings or concerning the consequential promotions given to the petitioners in writ petition 7 paragraph. On this short ground, the impugned order dated 20 June 2011 of the OAT in OA number 2787 of 2007 is hereby set aside. Paragraph. With the abolition of the OAT, the OA number 2787 of 2007 will now be registered as a writ petition in this court and be listed before the roster bench for hearing on 1st November 2022. By that date, we'll stop. In the said OA, the petitioners in 22148 of 2012 will stand impleaded as opposite parties. They should file their replies to the said OA, copy of which are already available with them, at least 10 days prior to that date. And the petition and the applicants, original applicants in OA 2787 2007 should file the rejoinder thereto before the said date. So the learned single judge will proceed to hear the said writ petition and endeavor to dispose it of as expeditiously as possible. The petitioners are disposed of in their workplace.
Okay. May I pray one thing? Name of Mr. M.K. Kuntia may be deleted, my lord.
All right.
Weekly list item number 56.
May I please, Your Lords? My Lord, the auction notice at Annexure 5, page 15 is under challenge on the ground that the very same shop is a very small shop by the BDA, my Lord, consisting of only 77 square feet. Same was allotted to the petitioner in the year 1995 by Annexure 2, page 9. My Lord, the petitioner is running his business and maintaining his family. And now, my Lord, all of a sudden the Annexure 5 was issued, putting the same shop to the auction. And till date, my Lord, the petitioner is in possession of the same and is paying the rent to the BDA.
What is the rent, sir? What is today's rent and what are you paying?
My Lord, I am appearing for the Bhubaneswar Development Authority, my Lord. My instruction is that even though we have not filed a counter, my Lord, but I have holding the para-wise comment with the documents which transpire, my Lord, the shop room has been cancelled since 2000, 24/5/2000, 24 May 2000. It has been cancelled because of non-payment of the license fees. Huge outstandings are against the petitioner. He is not paying regularly. That's not a correct fact.
So we'll make it conditional on that. What is the total outstanding as of date?
Yes,
As on date, I don't know, but on 2000, my Lord, it was 61,924 as on 2000, as on the date of cancellation, 24/5/2000. Now it would have been escalated. But the only grievance he is making that without hearing him, we are putting this shop into auction. We will hear him, my Lord, and we will communicate to you again that because of this default, it has been cancelled and you have not challenged so far. So far as cancellation, he has not challenged it.
1 minute, sir. You tell me, apart from that 60,000,
61,000.
Apart from that, has he been paying license fee regularly?
No, not regularly. He's not paying, my Lord.
No. What is the outstanding, sir? You tell us that. You're only telling us some 61,000 or as on 2,000.
Yes, my Lord.
What is today's 2022? What is the total outstanding?
That I will obtain instruction, my Lord. Your Lordship.
You obtain instructions?
Yes, my Lord.
We'll ask him to first deposit it.
Yes, my Lord.
Then he can be heard.
Yes, ma'am.
Yes, ma'am.
Counsel for the BDA points out that the license for the shop in question stood cancelled way back in 2000 due to default in the petitioner paying the license fee, which at that stage stood at around 61,000.
But till that, it has not been communicated to me, man.
He further states that even thereafter, the petitioner has been irregular in paying license fee. Stop. A direction is issued to the BDA to file an affidavit within 2 weeks in this court, clearly stating what is the exact amount of outstanding license fees owed by the petitioner to the BDA as of date. An advance copy of the affidavit be served on counsel for the petitioner to enable him to take instructions before the next date.
Next date
will continue. List on 26th October.
Okay. 26th of October, man.
Weekly list item 57.
My Lord, what is the date, my Lord? Your Lordship fixed, my Lord?
26th October.
26th October.
Item 57.
Item 57, my Lord, on behalf of Mr. Bikkenek, I have no instructions.
No instructions dismissed.
Weekly list item 58.
58, my Lord, permitted to withdraw, my Lord. Memo is in file.
Petitioner seeks leave to withdraw.
And therefore, the
memo is
opposite
taken
party is
under
your
court.
lordship.
All right.
Weekly list item 59.
On behalf of Mr. Swami, my Lord, no instruction.
No instructions dismissed.
Weekly list item 60.
My Lord, this is a PIL on moral policing resorted to by the police. My Lord, 3 young pairs were picked up from the park and they were made to kneel down before the police station under full public glare. Kindly see page 8, Annexure 2 photographs, my Lord.
So you notice from 1, 4 and 5 is not back. You have not taken any steps to even bring up these matters for hearing, sir. What you do is lodge a petition. 2013, you filed this petition and then you went to sleep.
Only opposite, yes, my Lord.
Yes,
only
you're admitting.
Only opposite.
I think you're not listening to what was being said.
My lord, only opposite party number 4. This
Have you heard what we said just now?
Opposite party number 4, the superintendent of police has filed the counter affidavit, my lord.
Yes.
But kindly see page 8, Annex 2 of the writ petition, my lord.
What is the relief you're seeking? I'm not able to understand. What is the relief you're seeking?
Relief, my lord, I have read for. The
exemplary action.
The Honorable Court may kindly direct the state government opposite parties to ensure a proper high-level inquiry with a view to fixing responsibility and taking exemplary
So how
action.
come in a matter like this, you went to sleep for 9 years?
And second, my lord, to take exemplary...
Sir, are you able to hear us? Or only you want to hear only yourself, or you also
No,
want
my
to
lord.
hear us?
No, my lord, sorry.
Considering the relief that you're seeking, he's not hearing again.
Kindly listen to us. What we are asking.
Hello. Yes.
Are you able to listen to us?
Yes, yes.
You're in a position to do that. Are you in a position to listen to us?
Yes, my lord.
Because when I start talking, you start reading.
Yes, my lord. Yes.
Everything is yes. Given the reliefs you're seeking in this petition, how did you go to sleep for 9 years? When I asked you, have you gone? Why did you went to sleep for 9 years? You said yes.
No, my lord, I filed memos, my lord. But the matter was not listed.
This is a standard response, sir. I'm not prepared to accept all that.
But this moral policing has been admitted by the superintendent police in his counter affidavit.
Has it? Has it?
Yes.
Come to para 4.
Counter affidavit, page 4.
Para 4.
Para 2, my lord.
Para 4, sir.
Para 4. That in reply to the averments made in paragraph 4.1 of the writ petition, this deponent respectfully states submits that the writ petitioner called upon to strictly establish his averments that 3 pairs of boys and girls were merely sitting and talking to each other in a park near Tulachana temple at Jaspur on 15/1/2013, and they were allegedly dragged by the police to the police station and made to kneel down in full public glare. Admittedly, petitioner is not resident of Jaspur town, nor was present at either the park where the young boys and girls were present, nor he has seen them being brought to the police station premises.
So you read this paragraph as an admission?
My lord,
this is how you read the paragraph.
My lord, kindly see page 4 and paragraph 6. Paragraph 6, second paragraph, my lord. The deponent further respectfully submits that...
Where are you reading, sir?
Page 4 of the counter affidavit, my lord. Second para. The deponent further respectfully submits that after receiving annexure A4 above, patrolling activities by the police was intensified, and on 15/1/2013, the police patrolling 3 young couples indulging in immoral activities at a public place.
So who's going to adjudicate this? So who's going to adjudicate this?
My lord, they have admitted. My lord, my submission is that
20 my lords will not answer the question, right?
No. The young boys and girls were taken to the police station and they were made to kneel down. The photographs have been provided, and here it is also admitted, my lord. Kindly, the honorable court may allow me to read out the paragraph.
Read it. All right.
The police patrolling 3 young couples indulging in immoral activities at a public place, being the park adjacent to Tilochanaswar temple known as Tilochan Park within Jaspur town, and the patrol party brought them to Jaspur police station for verification of their identities. The inspector in charge, Jaspur town, thereupon questioned them, asked their guardians to come down to the police station, and upon the arrival of guardians, and after discussion with them, the guardians insisted upon all 6 boys and girls being made to kneel down outside the police station for some time, where they were allowed to go to their respective homes with their parents and guardians. It is established, my lord. And the photograph showing the girls and boys were kneeling down, and the concerned IIC was with a baton, my lord. He was
Sir, in our
scaring.
system, therefore, we should simply go by photographs in newspapers, correct?
First photographs were
Only
taken
we
from
should
the
go by photographs in newspapers.
from the
We
newspaper.
should
Then I obtained the
ignore
photograph
all
from-
this. We should ignore all this, what the man is saying.
The photographs were taken by the journalist, my lord.
All right.
And it is also admitted that the boys and girls were were made to kneel down, my lord.
All right.
And it is happening under the public glare in the premises of the police station.
All right.
And my lord, in the photograph, the person wearing the T-shirt with a baton is the IIC, my lord.
All right.
It is established, my lord.
All right. What's his name, sir? What is an IIC? You are so confident. You say it has been established. What is his name?
His name is Alok Ranjan Nai, my lord.
Sorry?
Alok Ranjan Nai. I made him a party, my lord, not in his private capacity, but at the time he was the IIC, Jaspur police station.
So where is the notice served on him, sir? Can we pass an order without hearing him? Can we pass an order without hearing him?
At the time, my lord, he was the IIC.
No. My question is, can we pass an order?
If the honorable court directs me, I will make him a party, my lord.
Not otherwise. Suppose we don't direct you, you will not make him.
I have sought relief from the state, my lord.
Yes. What about whom will it affect? If we allow your writ petition, will it affect that IIC or will it not?
Because the police is doing all these things, my lord.
No, nobody needs to be heard.
No, I will make him a party now.
When will you file an application?
Yes, I will. I may be given time to file.
All right. Counsel, the petitioner seeks time to file an application to implead the concerned police persons as parties to the writ petition. List on 16th November.
My lord, the next
weekly 16th November. Weekly list item 61.
Obliged.
Item number 61.
Your Lordship, petitioner has paid for compensation in view of loss of crops and trees caused due to transmission of line from the captive plant to the
What is the statute, sir, which is involved here?
Indian Telegraph Act. They have exercised the power under section 164 of the Electricity Act, which says that it is to be made under Indian Telegraph Act. And Indian Telegraph Act says, my lord, section 10, if it is done, any work done, then they have to pay the compensation. If they have not done, then that will be decided under section 16 of the Telegraph Act. And but we have made.
I know. It's 2013. No counterfile, nothing. So no counter is filed at all.
Counter has
2013 onwards.
Because I have the parawise comments.
All in the file, not filed.
Counter has not been filed, unfortunately.
You say the representation annexure 6 of the petitioners shall be considered. Who's the district magistrate, collector from district magistrate Anugul, and after hearing, after notice to the petitioners and to the opposite parties, 4 and 5, and after giving them a hearing, the reasoned order shall be passed thereon, not later than 14th November 2022. The order shall be communicated to the parties not later than 21st November 2022. If agreed, to be open to the petitioners to seek appropriate remedies in accordance with parties to seek appropriate remedies. The court clarifies it has not expressed any view in the matter. After, yeah.
Well, may I request, I'm so sorry, may I have your lordship's permission to
Weekly list item number 60.
My learned senior Mr. Rajshekar Rao just to mention on
Yes.
BC, Your Lordship.
Yes, Mr. Rao.
I'm sorry, Malad, for landing up like the proverbial bad penny. Your Lordship had directed the matter to be placed before the other division bench. It came up before the bench headed by His Lordship Justice Viswajit Mohanty. Malad has recused. So, Malad, I am only requesting Malad, some protection either till Malad, the regular bench can take it up. Matters listed before the court tomorrow. The order sheet does not Malad, record the protection that was given to me on the previous occasion.
No, but we can't take it up like that. We don't have the papers also before us.
I'm sorry, Malad, that's what it's a peculiar situation. Then would your Lordship then permit me, Malad, if I could request the learned special court to accommodate us by a week, I'll request for Malad's...
I think so. I think so. We can place it tomorrow before another bench.
Would your Lordships then do that, Malad, if your Lordship will be kind enough to
We'll place it tomorrow. We'll ask the DR to place the papers. I tell you when I get up. All right. We'll place it tomorrow before another bench. All right.
Very well.
All right. All right.
Weekly list item 62.
No instruction, madam. Counsel to the petitioner states he has no instruction. Dismissed.
Weekly list item 63.
The memo is taken on record. Dismisses withdraw.
Weekly list item 64.
Dismiss the number.
Weekly list item 65.
Counsel the petitioner states his petition has been rendered infructuous. Disposed of.
Weekly list item 66.
My Lord, item 66, annexure 3 and 4 are challenged before your Lordship. My Lord, the lease was granted to a person, landless person in the year 1970. He sold the land in 1997 to one person. From him, I purchased it in 1993.
93, is it?
93. Sir, thereafter...
And notice did not go to you?
No, notice has been given to me by the Tahsildar. But it was fixed to 24/7/2002. On that day, matter was not taken up. Thereafter, no date was communicated to me and the order was passed cancelling the lease.
On
31/7/2002.
And the writ petition is filed in 2012. After 10 years, he has filed the...
But you should have followed up on that matter.
My Lord?
If on 24th July 2002, it was not taken up,
yes,
you should have followed up on the matter.
My Lord, it is the general rule is if they will not take it up, they will inform us the date. It was not given to us.
No,
so I was not able to know when the order was passed. I came to know and immediately I rushed to this.
Madam, suppose let's say today the matter is listed in this court. All right. It is not taken up today. Right? Then maybe a date is given today. You are not aware of the date. We give a date of, let's say, day after tomorrow. You have not come to check, so you do not know if it's day after tomorrow.
Here this matter is different, but in lower court matter is different. Generally, that is the practice.
What?
They will inform us when the
once a lawyer is engaged, then where is the question of
no lawyer is engaged. The husband of the petitioner appeared pursuant to the notice given by the Tahsildar. And thereafter, no date was communicated to us. Apart from it also, my Lord, I am a purchaser by paying the money and by registered deed. So, my Lord, I should have been made a party before, I should be heard before the lease was cancelled.
Well, that's why notice is going to you.
No, only one notice in the newspaper. In the newspaper, notice was published, pursuant to which my husband appeared on that particular date.
Beyond that, what is the obligation? Tell me.
My Lord?
Notice will go, the party will appear, then it's up to the party to continue appearing, right?
That is.
My Lord,
but in this case, notice was never issued to me personally. It was published in the newspaper.
Anyway, it served the purpose because you saw the notice, you appeared.
Your Lordship may kindly turn to Annexure 3. And status quo order is also operating. My only submission before your Lordship is that I may be given a chance of hearing. Since I have paid the money, I purchased it. So I don't have any fault.
My lord, what my learned sister is saying, that is quite a different thing. So lordship may kindly have page 28, annexure 4. Here, the resumption order was passed. That was challenged by the same petitioner in the appeal court. Before the sub-collector, the petitioner in this writ petition was the appellant.
Ah.
So how can she say that no hearing was? He herself challenged and she suffered an order under contest.
My lord,
on contest.
My lord, yes, I have referred an appeal against the order of the Tahsildar after coming to know of the order. And thereafter, without going into the details, I have raised 2 to 3 points. If your lordship will, may I pray one pass over? I don't have the file. I have taken the file. One person.
You can take the file. I am giving the file.
No, file has come.
All right.
Okay.
One person.
Weekly list item 67.
None appears dismissed. No possible.
Weekly list item number 68.
None appears dismissed. No.
Weekly list item 69.
69, your lordship may kindly permit me to file an appeal.
All right.
Order of
Assessment leave to withdraw this petition with liberty to file an appeal in accordance with law. Such appeal is filed not later than 12 September 2022, accompanied with an application for continuation of delay, citing the pendency of the present petition as the reason for the delay. It will be considered in accordance with law. The court clarifies it has not expressed any view in the matter.
There's no interim order.
The original of the annexure judgment be returned, subject to being substituted with the attested photocopy thereof.
I am appearing on behalf of the opposite party.
All right.
There's no interim order.
All right. The petition is disposed of as withdrawn with liberties paid for in the above terms. Right.
Weekly list item number 70.
Like that 70.
Yes.
Filed a further affidavit today. A copy has been served on the counsel for the opposite party's lordship. Just permit me to place a written note on the entire thing, because I have repeated the entire settlements which have been made in between while pendency of the case, and entitling the benefits which are there given to all the employees, your lordship, including the persons who are also involved in this case, your lordship.
That doesn't bind the union, Milord, as settled by your lordship.
No, I'm not saying the word union.
I am appearing for the workmen union, Milord.
All right.
Most welcome. This is the latest settlement dated 1/5/2022, and at page 23, your lordship, annexure 30, the employees who are members of the opposite party union, your lordship, who did not sign the settlement, they have been also extended the benefits at par with the persons who have signed the settlement. So no discrimination we have.
You have written that it is binding on them.
No, I'm not saying binding. Binding effect, I'm not going into that as well. I'm not going into binding effect. I'm saying that this I'm putting on record.
Fact is that, my lord, after the award, can they enter into a settlement by a set-up union, which a set-up union?
No,
this is age-old management taxes, my lord.
No, your lordship. No. And your lordship needs sees at page 24 how many left-out workers are there to get this settlement. I mean the award money, your lordship. 26. Only 26.
18. Oh. What is your submission, Mr. Monty?
Lord, it has been settled by your lordships by the Honorable Apex Court as late as 1975, 78 settlement, that the settlement entered into after the award by another union, even if 99% persons accept it, it is not binding, Lord, and it will have no relevance, Lord. Lord, 78 Supreme Court, 8 to 8, I have given it along with my note, my lord. Today I have filed a note, my lord.
Yes, I have been served a copy, your lordship. The clerk has received it, your lordship. But I am to just go through it. So that's why I propose to give a note from my side also, so that your lordship may fix a date and the matter can be heard. Finally.
All right.
A short date, my
Yes,
lord.
any day.
On behalf of the petitioner,
Any
a
day.
further affidavit has been handed over in court today,
Yes.
placing on record copy of the settlement dated 1st May 2022,
Yes.
arrived at by the management with 288 workmen.
Yes.
Full stop. Further, the affidavit encloses a list of 26 workmen who were not party to the settlement,
Yes.
but to whom the management has decided to extend the benefit of the terms of the settlement. Paragraph. Both Mr. Mishra, learned senior counsel for the management, and Mr. Mohanty, learned senior counsel for the workmen, state that they will be filing the written notes of submission.
I have filed.
Oh, Mr. Mohanty states that he's already filed a written note of his submissions on behalf of the workmen.
Along with the decision I intend to rely on.
All right. Along with the decisions he's seeking to rely on, Mr. Mishra states that he will submit his note of submissions before the next date.
Yes, sir.
An advance copy to Mr. Mohanty.
Lords.
May I pray for a short date, my lord? It is hanging. And the award has been passed in 2013, my lord. For 9 years, it has not been implemented.
Trying to find a date on which we don't have enough matters.
Your Lordship.
That's the biggest challenge.
Your Lordship. And it's a big LCR, Your Lordship. Has all the documents been scanned?
It's not been necessary. I don't think it is going to
28th September. Sir.
Yes.
28th September.
He is trying to scare us.
Anyway, the digital format, nothing scares us.
Your Lordship, I remember my Lord Justice Parija was also handling this particular matter for one day. He said that you being the management, please provide us some handling allowance for handling this. Grateful, Your Lordship. Grateful.
In remote country.
Yeah.
Weekly list for admission, item 71.
71 would be infructuous in it.
Infructuous. Okay. None appears for the petition. Dismiss number.
Item 72.
None appears to dismiss number.
Weekly list item 73.
None appears to dismiss number.
Weekly list item 74.
None appears to dismiss number.
Weekly list item 75.
None appears to dismiss number.
Weekly list item 76.
None appears.
Weekly list item 77.
May I please, Your Lordship? In this petitioner, my lord, the petitioner is the resident of village Pratap Sasana, my lords. And since due to the expansion of the Bhubaneswar locality with this, the lands in this petitioner's village are being taken away, being encroached by the general public to grab the lands. And
I think this happens that the encroachers are not made parties.
No encroacher.
You have to make the encroachers parties. Sir. You make a fresh representation after naming the encroachers. You say, counsel, the petitioner seeks leave to withdraw the petition to with liberty to file a fresh representation to the authorities after naming the encroachers. After ascertaining the encroachers, to make a fresh representation, naming the encroachers. And after following up on such a representation, to seek appropriate remedies in accordance with law. This post of is withdrawn with liberty is paid for in the above terms.
Weekly list item 78.
None appears to dismiss.
Weekly list item 79.
May I please, Your Lordship? This is a public interest litigation, my lord. My lord, Your Lordship will find this is, my lord, in Sukinda area in the district of Jaspur. My lord, there are, my lord, large scale mining operations are being carried out, my lord, around 12 mining setups are there, my lord, who are having, my lord, no pollution control certificate and other things, my lord. My lord, your lordship knows the present position of the, my lord, present precarious situation that has occasioned at Sukinda, my lord. My lord, 60% of the drinking water contains hexavalent chromium level, which is double the standard of the international standard, my lord.
No, 1 minute. And then you go before the NGT. If the pollution is the issue, then you go before the NGT.
No,
These are the matters
no,
which
these are
ought to be educated before the NGT.
these are all admitted facts before your lordship.
That's right. It'll be easier before NGT then.
My lord,
if everything is admitted.
I'll just show to your lordship kind attention to 2-3 annexures, my lord.
Why don't you go before the NGT, sir?
No, the petitioners are very poor persons.
Why not, sir?
They cannot
If they can come here, they can easily go to the NGT. It's only
Calcutta and fight out the cases.
Why not, sir?
And if we send it through, my lord, another matter your lordship had directed me to go before the NGT. I sent it through, my lord, their mail, my lord. But it was not neither registered.
So from here to Calcutta is hardly any distance, sir.
My lord, hardly any distance.
There are people going all the time to NGT. And many environmental lawyers, activists are going to the NGT Calcutta.
But whatever is there, that is there on record, my lord. Definitely they cannot be much better than your lordships, my lord.
No, nothing.
Your lordships are, my lord.
No, we don't claim that at all, sir. You are slightly mistaken. This matter came up on its own today because we have listed it.
No,
otherwise it would not have come up for the next 5 years. No, at that time you will not be saying this.
After giving memos, also the matters are not being listed.
Everything is our fault, sir. We accept. All the fault is only ours.
No,
totally. Nobody
say, my lord.
Lawyers are never to blame, sir. The fault is only court and only judges.
And they
no fault of the lawyers, sir. Only judges.
My lord, your
in the last 1.5 years, have you mentioned this matter before me?
This case, my lord. No, I am sorry, my lord.
But still, it is our fault, correct?
No. I am.
Yes.
I am not.
That is what you are saying,
my lord. I am not making allegation that way, my lord.
You have not lifted a single finger to have this matter listed in the last 1.5 years, and still you say only the court is to blame.
No, I am not blaming the court, my lord.
Yes,
I am sorry, my lord. If my lord, your lordship has taken it that way, my lord. My lord, I am very sorry to say, my lord. I have never made any allegation that way, my lord. My lord, only thing is,
we are already overburdened. We have not been able to take up this matter for over 4 years. The idea of creating the NGT was precisely to deal with these kind of issues. They deal with it on a daily basis. We don't deal with this on a daily basis. We deal with it along with several other matters. That is why these tribunals have been created.
May I pray one thing?
And they have the expertise to deal with this.
May I pray one thing, my lord? My lord, your lordship may direct. My lord, on my sending the brief through mail, my lord, they will register and take up the matter, my lord. My lord, otherwise they are not registering even, my lord.
So we don't know the procedures in those tribunals.
That is exactly what I am saying, my lord. We also do not know and we have never done there, my lord.
Your client saying you don't know is different from the lawyer saying you don't know.
No, I have never gone there, my lord.
So that doesn't mean that there are no lawyers appearing there.
It is on VC.
There are many lawyers. There are many lawyers from Cuttack who are going to NGT. If you want us to ascertain the list of those lawyers, we can do it. Because we have no other work, we have a lot of spare time, we will do it. And we'll also organize some classes how to file cases in the NGT.
Anyway, my lord, I will try to, my lord, find out the ways, my lord.
All right. Counsel, the petitioner seeks leave to withdraw this petition with liberty to approach the National Green Tribunal in accordance with law. This post of is withdrawn with liberty is paid for.
Weekly list item number 80.
Nana, please, this is not possible. Oh, he's there.
Your lordship may kindly turn to page 12. 12 by annexure 2, annexure 1, your lordship may kindly see. Illegal construction over the Gochara land, my lord. And your lordship may kindly see almost all the Gochara lands have been forcibly occupied by the right hand column. Your lordship may kindly see. almost all the Gochara lands. And we are concerned about plot number 427 at page 12, your Lordship may kindly see. 427 and one
76.
Case has been instituted under OPLE Act and the order has been passed for eviction, but they are not carrying out that order, my lord.
So no notice has even gone in this petition.
The state has already filed counter. Your Lordship may kindly, they have already admitted. Your Lordship may kindly see para 13, your Lordship, para 13 of the counter, running page 43.
So no notice has gone in this petition for the last 4 years.
I think my learned friend is holding a wrong brief. Which item? 76.
80.
80.
80 is WPC 1040.
So we are having 10403.
Yes.
3064.
That is 76. That is already dismissed for default.
So we called out item 80 now.
80.
76.
When we call out 80, if you get up, then we are assuming you are appearing in 80.
I am there.
He just now called out item 80.
He thought that his case is item 80, but it is 76.
76.
So we are now in 80. Now who's appearing in 80?
Nobody.
76, your lords.
No.
None appears to Susanapa. 76. Now you call out what happened in
76.
76.
That is not.
Anyway, he's now there.
Annexer 2, page 10, 13, your Lordship may kindly see. Almost all the right hand side column, your Lordship may kindly see, almost all the Gochara lands, Annexer 1, your Lordship may kindly see, all the Gochara land under forcible possession of private individuals, my lord. And we are concerned about plot number 427. 427, one encroachment case was initiated and the order has been passed for eviction of the encroacher, my lord. But till date, no action has been taken, my lord. The Lordship may kindly see, all the Gochara lands have been forcibly being occupied in possession of individuals, my lord.
And the mandap,
just read para 7 of the counter.
Para 7.
Main thing my learned friend is not placing. There is a Kalyan mandap over the disputed
That's what that was asking to read.
Yes, he is not placing.
Yes, that mandap. That is a construction which has been constructed by an individual, my lord. Not
just read that para 7, sir.
Yes, at the outset it is submitted. The mandap has already been constructed over Gochar Kisam of land, and at the behest of village committee members as well as elected ward members and Sarpanch of Mangalpur Gram Panchayat for betterment of local people. Demolition of mandap will create law and order situation in the locality. That apart, Collector Dhenkanal, while disposing of the representation in obedience to Order dated 2/4/2015, passed by the Honorable Court in WPC number 5669 of 2015, has specifically observed that the mandap has already been constructed. Will use for the better interest of the general public. Further has issued a direction to the BDO Sadar Dhenkanal as well as the Tahsildar Dhenkanal to not to release any fund for the purpose of further construction of mandapa, and the land where mandapa has been constructed shall not be settled in favor of the villagers under OGLS Act and rules. In the Gochara land cannot be used for any other purpose. Your Lordship, OGLS Act.
Next is important. Next is important. Admittedly, there are two groups in village Nadhanpur. One group is supporting the construction of mandap. Another group is opposing the construction. Due to political rivalry, one group of villagers have filed the present writ petition before the Honorable Court for demolition of the mandap, which has already been constructed over plot number so and so in the district of Nana. In such view of the matter, the writ petition filed with this. There were earlier a writ petition.
Para 13, your Lordship of the counter at page running page 43, my lord. Your Lordship may kindly see that with regard to our averment made in para 4.1 of the writ petition, it is submitted on the basis of representation filed by some villagers. RI Sadar was directed to make field inquiry and submit a report on the basis of Form G filed by RI Sadar. OPLE case number 17 of 2015-16 was instituted against Pramod Kumar Parida, ward member of Nadanpur, for illegal construction of mandapa over government plot number 427 Kisama Gochara. And by order dated 23/6/2015, the Tahsildar Dhenkanal has passed an order of eviction in OPLE case number 17 of 2015. Already eviction order has been passed, but that is not being carried out, my lord, at the instance of the ward member, my lord. And almost all the Gochar land, your lordship may kindly say Annex or 1, that has been illegal in occupation of position of all the.
You are only concerned with 427.
427.
That so this paragraph means that the ward member, this is not what my learned friend has said, that some private individuals have constructed. That is not this. This is the ward members and the local sarpanch out of the government fund they have constructed. And so by the time this initiation of OPL proceeding, the mandap was already over. And this is for greater interest of the general public of the villagers, that the collector has decided in the order which I have annexed in the counter affidavit as annexure A by 2. That your lordship may kindly see. They have suppressed in the writ petition. They have suppressed that earlier there was a writ petition at their instance, and the honorable court has directed the collector.
No, not my instance. At the instance of another individual of the village.
Anyway, you are also member of that village committee. You are a member of that village committee. And one village committee will file
illegal construction objected.
So multiple writ petitions have been filed.
Representation was filed before the collector, and that was not dealt with. So
not dealt with. Annexure A by 3 at page 11.
That earlier writ petition was filed for disposal of the writ petition, my lord.
Disposal of the representation.
Representation.
That was disposed of. That is annexure A by 2, page 11 of my counter affidavit, with a reasoned order.
There, my lord, eviction order was passed, and that was not carried out.
Because of the same law and order and all of that. They don't want to have all this trouble in their hands.
And that too.
And that now they are protecting the illegal construction, my lord, protecting the individual, my lord, saying that.
Is for public interest for the entire
no, not public interest.
And that a single person is using it, and some villagers due to political rivalry, they are can imagine what is the background.
No political
it is there. We have avoided it in our counter.
And fund was released for construction of the mall in a different plot number 27, my lord. And this individual constructed the.
Where you have said so.
Yes. In the region, you itself admitted. Your lordship may kindly see that order also says that. Yes, page annexure 1 by 2 at the bottom, my lord, page 48, running page 48 at the bottom. Their village, Prashant Kumar Behra are forcible constructing the mandapa over government Gochar land pertaining to plot number 427 under holding number 127 Rakhita of village Nadanpur instead of plot number noted in the work order, that is plot number 73, my lord.
See the 10 villages of village Nadanpur, P.O. Mangalpur, P.S. Denkanal Sadar have filed the present PIL asking for removal of illegal construction on plot number 427 in Rakhita Khata number 127 of Moza Nadanpur over an area of AC 0.090 decimal. Paragraph. In response to the petition, a counter affidavit has been filed on behalf of opposite parties 1 to 4 by the Tahsildar Denkanal, where inter alia it is stated in para 7 as under reproduce para 7. Paragraph. It has further been averred that in the same village there are two groups, one opposing the mandap and the other supporting it. Full stop. It appears that out of the total area of 0.09 decimal, only AC 0.01 decimal has been used for construction of the mandap, and the remaining land is still lying vacant, and villages of Nandanpur are still using the same. Full stop. The contention of the opposite parties is that majority of the villagers are supporting the construction of the mandap, and that the present petition has been filed out of some political rivalry. Paragraph. there is a denial of the above arguments in the rejoinder affidavit. Full stop. However, the fact remains that the mandap has been in place since 2015.
Yes, ma'am.
That is for more than 7 years, and is obviously being used by the villagers. Full stop. By the time the order was passed in the OPLE case number 17 of 2015-16, the mandap was already in place. Paragraph: the local administration is in the best position to assess the possible law and order implications of any
by the order was
coercive action. Full stop. It appears that since the petitioners are a smaller group which is opposing the mandap, and in view of the circumstances explained in the affidavit of the Tahsildar, the court is not inclined to issue any directions for removal of the mandap at this stage.
Well, may I submit, my lord? By the date the order was passed in OPLE case, the mandap was not constructed. Thereafter, completed.
Anyway.
And no action was taken. From the initiation of the construction work, I have been representing the collector, Tahsildar, no action was taken. And section 3 says that it cannot be used for any other purpose, my lord. Your lordship may can see OJLX Act. Section 3 proviso says that Gochar land cannot be used for any other purpose, my lord.
So the entire land has not been used. Some 0.01 decimal has been used.
No, 0.01.
0.09 is still vacant, that you've not denied.
And part by part, they will occupy all the land. Gochar land will not be there at all, my lord. Your lordship has seen that Annexure 1, all the Gochar lands are under forcible possession of the individual.
They have said in their affidavit that only 0.01 is used. Yes.
In rejoinder, I have stated, your lordship may kindly see. All the lands are in forcible possession. Gochar land are in forcible possession of the land grabbers, my lord.
All right. Petitions accordingly disposed.
Weekly list passed over matter. Item number 53.
53, my lord. I may plead lordship, my lord. Item 53, I have taken instruction that the management in the meantime has been changed. However, they are willing to deposit the amount with the lordship grant 2 weeks time. But one thing your lordship can see, the notice was duly served on the OP number 2 on 30th January 2013. But still yet he is not appearing and they are not taken any steps. That is, AD is back from the OP number 2.
AD is not back. AD is not back, sir.
Yes, my AD is back on the record. There. On 30th January, they have received the notice, madam. The last in the AD is there, madam. That is there. 30th January, madam.
Where is that?
Yeah.
And nobody is appearing for him?
Yes, madam. May I suggest, my one thing, your lordship may observe that any cause of action survive, the party may reduce their grievance because perhaps there was a compromise at the relevant period.
Counsel to petitioner states that on instructions, states that the management has changed and it's possible that there was some compromise between the erstwhile management and the opposite party number 2 workman. He accordingly craves leave to withdraw this petition with liberty to revive it in case any fresh cause of action arises. All right. Arises. Disposed of is withdrawn with liberty spread. All right.
Passed over matter item 66.
66. There is a provision for revision under
Section 7A of the OJLS. He can approach.
All right.
The collector.
Petitioner seeks leave to withdraw this petition with liberty to approach the avail of the remedy of a revision petition against impugned order under Section 7 capital A of the OJLS Act.
My status quo order was there.
If such revision petition is filed not later than 12 September 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as a reason for such delay, then it will be considered in accordance with law by the revisional authority.
Noblesse. My lord,
If the
urgent copy
revision
of
petition is filed within the aforementioned period, accompanied by an application for interim relief, then till such time the said application is disposed of, the interim order passed by this court on 30th August 2013 will continue. The original of the annexures be returned subject to substitution with attested photocopies thereof. The petition is disposed of as withdrawn with liberties prayed for in the above terms.
Oblige, my lord. My lord, urgent copy of your lordship, sir.
All right. Supplementary. Urgent copy be issued as per rules.
Supplementary list fresh admission item number 1.
Lordship, kindly permit me to withdraw to file a better application.
Council petition seeks leave to withdraw this petition with liberty to file a better petition. Disposed of is withdrawn with liberty to pay.
Supplementary list item number 2.
May I please, Lordship? My lord, it is a PIL matter, my lord, relating to unauthorized encroachment of the public land, my lord, in the area of Banki, my lord. At page 17, my lord. These lands are encroached by the encroachers, my lord.
Or where is your representation has been served on the other side?
Annexure 3 series, my lord. At page 35, my lord.
All right. The petitioner's representation shall be examined by the.
But there is no endorsement of.
No, this post.
Oh, sorry. I'm sorry.
Ah.
It is
Examined by the Tahsildar.
Collector.
Collector. And after issuing notices to the petitioner as well as opposite parties 4 and 5, and after giving them a hearing, a reasoned order shall be passed not later than 17th October 2022 and be made available to the parties within a week thereafter. The court clarifies it has not expressed any view on the matter. Petition is disposed of.
Much obliged, ma'am.
Supplementary list item number 3.
Item number 3, my lord, I am for the respondent, my lord. Earlier, when you lost directive to present the respondent, no, he is a present, my lord.
Where is the money, sir?
Now outstanding is 58,000. Total outstanding is 78,000. On another data already, I 20,000 already.
So he's brought 58,000 now.
58,000 now pending.
Or where is that 58,000?
You pray for my lord 1 month time to.
I thought you had the 58,000 with you, sir.
No, my lord, he is
today he should have brought some amount at least.
He is a battle shop owner. He before 1 month in bad reading, my lord. That's why not unable to, my lord, to pay this at.
So we'll increase. The more you delay, will increase the amount.
Yes, I know that. He also.
What is the amount he's brought today? No. You're asking him like this. You didn't tell him that he should bring some amount today.
He requested within 7 days he's deposit some amount, my lord. Within
what is the total outstanding now?
Total 58,000.
58,000.
Yes, my lord.
So asking him is 25,000.
Who installment, your lordship?
You bring 25,000 at least within a week.
Yes, my lord.
The respondent is present in person. He gives an assurance to this court that on or before (8th August), he will pay the appellant rupees 25,000 of the balance amount of rupees 58,000. Report compliance with the above assurance list on 10th August. Call it on 10th August, sir. The respondent will continue to remain present in person.
Supplementary list item number 4.
Lordship, on all these batch matters, Lordship, kindly see order dated. Lordship, second date application, Lordship, that is 14078. Rehabilitation assistance, Lordship, and last occasion was directed only to verify the judgment of Honorable Apex Court, Lordship. That is that.
What's the position, sir? Now there's a judgment saying scheme that is applicable at the date of the judgment.
Lordship,
In fact, in paragraph 5, their lordships have held, we have noted that there is a conflict of view as to whether the scheme rules in force on the date of the death of government servant would apply or the scheme rules in force on the date of consideration of the application on compassionate grounds would apply. There are divergent views and the conflict of opinion in different decisions of this court. However, keeping the said question aside, for the reasons stated here in below, we are of the opinion that in the peculiar facts and circumstances. So considering the facts therein, Honorable Apex Court directed that no, you consider her application on the date when his application was submitted.
Then para 9, Lordship, kindly see for a moment, Lordship. Para 9. At the same time, the responsibility of the state, Lordship, in such
is prospective. Para 9 direction is prospective.
Please go through para 9 first.
Yes.
I would copy it. Let the court keep it. I'm collecting here.
So all that is fine, but the point is there is a conflict of views.
Lordship, kindly see, Lordship, just in the meantime, Lordship, number of cases has been disputed by Honorable Single Judges, Lordship. The court benches, Lordship, disposed many cases, Lordship. And nothing to survive. Prevalent rule only, Lordship, to see whether the prevalent rules, whether I'm applicable, I'm coming under the old rules or not, Lordship. If my death is prior to that, then definitely, Lordship, my application is also on the date of the, just after date of the death, Lordship. Lordship, kindly see the last time prepared a death chart, Lordship.
No, I prefer we wait for it has been referred to a larger bench, the Supreme Court. No, is there a larger bench?
No, before the Honorable Apex Court, it has been referred to larger bench.
It has?
Yes.
In which order?
Santosh Kumar.
Same order. This case, nothing, Lordship, nothing. This case has never been referred to larger bench. Single judge order.
In Santosh Kumar, in paragraph 16, it is held a two-judge bench headed by so-and-so J noticed the Supreme Court view in SBI versus Rajkumar and MGB Grameen Bank versus Chakravarti Singh on one side and the contrary view in Canara Bank and M. Mahesh Kumar and felt the necessity of resolution of the conflicting question on whether the norms applicable on the date of death or on the date of consideration application would apply. Accordingly, in SBI versus Shiv Shankar Tiwari, the court referred the matter for consideration by larger bench so that the conflicting views could be reconciled.
Where are you reading, sir?
Paragraph 16 of NC Santosh judgment.
But that is not subject matter here, Lordship. We are relying upon Lord Justice, the case of Lordship, that is Malayan and Sethi. It is much after the Lord that and Santoshi.
Malayan and Sethi notes the fact that there is a conflict.
But Lordship, para 9 for a moment, Lordship can see. After the disposal of the writ application before Honorable Apex Court and Lordship, can see the order of the Honorable Single Judges, Lordship. Many matters have been disposed of with the direction to dispose or to consider grievance in the light of the
several matters have been set aside.
That is on the ground of delay, Lordship. Here is on the ground, it is the state laches.
No, not
in all these cases, Lordship, due to laches of the state, we have been suffered. In other cases, Lordship, delay was there.
Let's wait for the larger bench. In view of the reference made to a larger bench of the Supreme Court in SBI versus Shiv Shankar Tiwari.
Lordship, may I permit to withdraw all those cases, Lordship?
These petitions?
Lordship, because Lordship, if you're pending, Lordship, for outing the judgment of larger bench, Lordship can see the Honorable Single Judge. They are saying to constitutional representation. If at all succeed, then we'll get a job, Lordship.
So you withdraw them?
Lordship, that's how we'll withdraw the petition after their Lordship.
All right. Counsel for the petitioner seek leave to withdraw the present petitions with liberty to approach the government.
Honorable Single Judge, Lordship. Because here we have challenged the validity of the statute law. Will not challenge, Lordship.
All right. With liberty to approach the Lord Single Judge.
Lordship.
In accordance with law.
Obliged.
This post office withdrawn with liberty.
Lordship. Obliged.
All right.
All those matters.
Right.
There are other matters are also there. Item 16 is there. Or 16, 20, 21, 22. 16, 21, 22.
No, all the petitions are their petitions, sir. You are appearing in those, you are saying?
Yes.
Please appear with me.
Supplementary list item number 5.
Right. My lord, this is public interest litigation against the Mahatma Gandhi National Rural Employment Guarantee Act that has been running in Raitala Gram Panchayat of Dhenkanal district.
So too many defects, sir. You remove the defects.
My lord.
Defects we removed within a week. This thereafter.
Supplementary list item number 6.
May I please? I have already served copies on my learned senior Mr. Chimanka Milot. The other two defects may kindly be ignored because opposite party number 3 Milots, I have given the building name of the building and Visakhapatnam Milots. So that is the complete address of opposite party number 3, the principal commissioner Milots.
All right.
And
yes, Mr. Chimanka. Yeah. What is the matter?
No, the matter Milot stands covered by best infrastructure's judgment Milot and Andaman judgment Milot. The point, my lord, is in a raid where a statement has been recorded under 132(4), my lord, of the Income Tax Act, whether it will constitute incriminating materials. Number two, my lords, my specific case is that I have, my lord, named 3 persons on whose statement my assessments were being made under 153C, my lord, for cross-examination. That has not been given to me, which is contrary to Andaman's case, my lords. If your lordship would kindly turn to, my lord, page 55, my lords.
No, but tell me one thing. You're challenging the assessment order.
No, I'm challenging the assessment order on the ground, my lords, that this particular assessment order has been made, my lord, basing on the statement of 3 employees of the searched person, my lords.
That's all.
Lord,
this can be
no, your lordship may kindly, my lord, turn to page 55, my lord, for a moment. Because that will be contrary to best infrastructure and Andaman's, my lord. But my specific
all
application
that can be raised in appeals.
Not by cross of the, my lord, your lordship would appreciate my application for cross-examination is there, my lord. I specifically say at page
all
74.
That will be a ground in appeals.
Violation of natural justice, my lord.
All that.
Not Andaman timber, my lord. Your lordship would kindly permit me to.
No, you can cite this before the CITA.
My lord, your lordship may kindly see the Andaman timber, my lord, for a moment.
No, we've seen that. No, this is only a ground for.
No, in this case, my lord, following these two, my lord, no incriminating material, and following these 2 decisions in Sai Cashew, my lord, your lordship has been kind enough to interfere in an assessment order, my lords.
Right.
And if your lordship would kindly turn to page 38, my lord, of best infrastructure, which has been subsequently taken up to the Honorable Supreme Court and the SLP has been dismissed, my lords.
I know, but this was in an ITA.
Sorry, my lords?
This order was in an ITA.
No, my lord. This was in an ITA. But Andaman's, your lordship may also see, my lords. Andaman's, why they have struck up not paragraph 6 to 9, my lords. Your lordship may kindly see paragraph 6 to 9.
These days, the CITAs are very smart, sir.
My lords, your lordship. Your lordship knows in the faceless assessment scheme, my lords.
Ultimately, somebody's sitting there.
Yesterday
don't have AI.
Yesterday, my lord, yesterday your lordship gave the example of AI, my lord, where so a lady who is not connected with the matter, she was taking down notes. Your lordship may kindly permit me, my lord, the Andaman.
No,
your lordship may kindly, my lord, appreciate, my lord, at least one opportunity to cross-examine him, my lord.
I know, but
it was only basing on these 3 statements.
You say at this stage, when there is only an assessment order.
Your lordship may
I'll permit you to withdraw to go in appeal. That's far better for you. You say counsel the petitioner seeks leave to withdraw the present petition with liberty to file an appeal in accordance with law against the impugned assessment order dated 30th March 2022. Is there any delay thing for you?
Yeah, no, there will be because there'll not be any delay so far as CIT appeals.
All right.
Perhaps there's not.
All right.
No, there will be so far as.
Yeah, in the event of any delay, the period during which the present writ petition was pending will be taken into account by the appellate authority. The petition is disposed of as withdrawn with liberty is paid for.
The second matter is also the same.
Same.
My application can noted.
Yes, Mr. Chamka.
Right. Supplementary list item number 8. Supplementary item number 8.
Even legal services authority, there's no way.
My lord, in this case, Lordship direct for the status report of the my lord petitioner. I have filed my lord status report inquiry by the BDO Manesar, district of Sambalpur, my lord.
You are appearing for
What's the status?
Status, my lord, the petitioner is died, and his legal heirs is alive, and he has 2 wives, and more than 5 children are alive. They are clearly stated in all the paras. And in para 2, the 2 daughters are residing, and their son is maintaining their livelihood in the profession of the barber. Then, my lord, the petitioner has 2 sons, which is reflected in para 3. Para 3, the petitioner died on my lord 20th January 21. Para 3 status report, my lord. Document
1 minute. Where is the status report? Where are you reading from, sir? You're not giving us a copy.
This one I have solved.
No, we don't have a copy.
What copy?
Already I have filed, my lord.
Yeah, would it be your I have heavy.
So what do you want to say, sir? As a result of this status report, is there anything you want to add?
My lord, petitioner, when the land was grabbed by the company, they are seriously prejudiced before the administrative authority, but they harassed. Thereafter, they wrote a letter to the President of India. They would pray for the end of the life. And last date also died. What is the status of the present
No,
petitioner?
there is a counter affidavit of the Tahsildar Maneshwar. Have you seen that? Have you seen that? There's a counter affidavit of the Tahsildar Maneshwar.
No, I have the.
All right. The counter affidavit, copy of the counter affidavit of the Tahsildar Maneshwar. You must be having it, Mr. Monti.
Yes, I'm just now.
Has been handed over to counsel to Mr. So and so appearing for the petitioner.
Those.
He seeks time to study it and make submissions. You say, and then a status report has been filed by the Secretary, OSLSA. No, a status report submitted by the Block Development Officer Maneshwar has been placed in record by the Secretary, OSLSA. Deputy Secretaries, OSLSA, which has been perused and is placed in record. List on October 26th.
Supplementary list item number 9.
On behalf of Mr. G.K. Mohanty, the petitioner ancestral landed property has been illegally sold in connivance with the local government officials, my lord, causing huge revenue loss to the government, my lord. My lord, on the last occasion, my lord has directed the State Council to file an affidavit explaining why the sanction order has not been passed in respect of 3 OS officers, my lord.
Yes, please.
Yes, my lord. I have filed the affidavit. Actually, what has happened? The Vigilance Department has sought for permission. It is pending before the GA Department. So, as per the affidavit also is there on the record that the District Vigilance Cell is unable to say why this. In the meanwhile, what is the development? I wrote a letter from my side that what is from the GA Department. GA Department is not a party here. So GA Department, I have requested him to why the matter is so pending for last so many years and why that we have to get information from the GA Department.
All right. At the request of Mr. Monti, we need some more time to comply with the order dated 5th July 2022 list on.
My lord, may I request one thing to your lordship?
Yes.
Since it is a PIL, your lordship can include the GA Department. And since the matter for regarding sanction is now, we can include the GA Department.
No, I'll just record on the strength of this order, you can get it.
Okay.
Mr. Monti states that he has already contacted the General Administration Department for instructions.
I have written letter.
In terms of the order dated 5th July 2022, the GA Department is directed to provide those instructions forthwith. An affidavit will be filed before the next date. List on 14 September 2020.
Supplementary list item number 10.
Item 10, my lord, kindly pass over. I am for the petitioner, my lord.
All right.
This was on the request of Mr. Mishra. Your lordship specifically fixed it today. So, Asubar, my lord, your lordship will then call it some other day. I will be inconvenienced.
Why? It's only 3 o'clock, sir. It'll come up now.
Supplementary list item number 11.
Item 11 on the last occasion.
May I please, your lordship?
My friend wanted to peruse the report.
Pursuant to order dated 7/7/2022, my lordship, the petitioner has verified his service record.
Item 11.
Yes, pursuant to your lordship's order dated 7/7/2022, my lordship, the petitioner has verified his service record. And after verifying, my lordship, I don't think I can add or substantiate anything further. So without recording my consensus, your lordship may pass appropriate order.
All right. Order.
My lordship, please consider this judgment.
All right. Orders reserved.
I have a small request, my lordship.
Yes, please.
Name of Mr. B. Rautre may kindly be indicated, my lordship.
Oh, yeah, sure.
I'm an associate of Mr. B. Rautre.
Correct.
My lordship.
Yes.
Great.
All right.
Supplementary list item number 12.
My lord, that 12 is the PIL matter, my lord. Last occasion, directorate to the officer to 5 NHA
Yes.
to file reply, my lord.
No, pursuant to your lordship's
record should be kept.
Order number 4, my lord.
The early matter 11. You give an inspection.
Order number 4, that is 26/4/2022.
Record be sent to us.
Pursuant to your lordship's order, my lord, I have obtained instruction, my lord. The proposal for construction of underpass under the change of scope has been approved in principle by the competent authority.
Oh, very good. Very good.
I seek some 7 days time to file accompanying the letter of approval.
All right.
So that it will be adjudicated.
All right. Very good. Very good. Mr. Amitav Das, Learned Counsel for the NHAI, seeks and is granted 2 weeks time to file his reply. File an affidavit placing on record the decision of the NHAI in the matter. List on. We'll have it early, sir. 10th August. 10th August.
No, my lord.
17th.
Yes, 17th August.
Yes, sir.
17th August.
My lord, appearance of Union of India may not tell, my lord, in this case, my lord.
All right.
Supplementary list item number 13.
May it please, my lords. My lords, in item 13, my lords, this is an ITA under section 260A. My lords, the questions of law are at page 9, my lords. The short point that is to be adjudicated before your lordship says, my lords, whether a shareholder, whether the deemed dividend under section 2, subsection 22, clause E is to be added, is to be taxed in the hands of the shareholder, or should it be taxed in the hands of the entity where such shareholder is a partner? My humble submission, my lords, is that it should be taxed in the hands of the shareholder. Why? My lords, because it is a dividend, and a dividend, my lords, is to be taxed in the hands of the shareholder because it's the shareholder who is the beneficiary.
No, but this is a settled question of law. I don't think it will be.
Yes, my lords. There is, if your lordships would permit, my lords, I'll share. In fact, I relied upon a particular order of the or judgment of the Honorable Madras High Court, which precisely says so. But the Honorable Tribunal did not regard to that and has passed an order that no, it has to be taxed in the hands of the entity, not in the hands of the shareholder.
No, this is ITA 18.
Yes, my lords.
Page 18 may kindly seen.
Your lordships, if your lordship will permit, I'll just take your lordships through the pages, my lords. Page 13, the impugned order starts, my lords.
No, your contention is at internal page 5.
My lords. Yes, my lords.
Just see para B, internal page 5.
Internal page 5 of the tribunal order, page 17, running page 17.
No, of your appeal. Para 5B.
Yes, my lords. That the learned Commissioner of Income Tax Appeals accepted the submission made by the appellant and has observed that since the appellant firm is not a shareholder in the paying company, that is Messrs. Orissa Stevedores Limited, the amount disbursed to the appellant firm from the said paying company should not be treated as deemed dividend in the hands of the appellant firm, but the same should be treated as deemed dividend in the hands of the individual director, Shri Mahimanda Mishra, who is a director in the paying company with substantial interest and is also a major shareholder as a part of the appellant firm. So my humble submission, my lords, is today before your lordships is a partnership firm where this person, Mr. Mahimanda Mishra, is a common is a partner in this firm, that is the firm that is there before your lordships today, and also a shareholder, major shareholder in the company which has made payment of unsecured.
No. So your contention is that it should be taxed in his hands.
Yes, my lords.
And not in the firm's hands.
Yes, my lords. Precisely. And this being a my lords dividend, my lords, has to be taxed in the hands of the shareholder. And my lords, Enor Cargo, the judgment that I've relied upon, your lordships precisely says so, which has also distinguished, my lords will see at page.
All right. You say admit the following question of law is framed for consideration. Whether the what
Page 10, para B may be the para B and D. Millards.
I think only D, right? Whether the deemed dividend paid by the Orissa Stevedores Limited
Whether
should be
the
taxed.
Yes,
Should be taxed in the hands of Mr. Mahimananda Mishra, the individual director who has a share therein, or in the hands of the appellant firm of which he is a partner. Correct?
Millards, precisely.
Right. That's it. List in due course.
Millards, just one small thing that I wanted to point out, Your Lordship. For
Yes.
a moment, page 18.
Yes.
Tribunal has actually gone on a very tangent. Further, it is not clear, the last para, it is not clear as to whether it is taxed in the hands of the SSC's partner, and AR could not. AR means the SSC's representative, could not substantiate the fact that the shares invested by the director are not out of funds of the partnership firm.
There's a presumption that the firm is holding the shares. Anyway,
Yes.
that's not even, it's
Millard, the
but
last
only
line, that is completely tangent, Millards.
yeah, anyway, it's only remitting to the CIT. Once we frame this question, nothing happens. All right.
Yes.
All right.
I'm grateful.
Last two line is important. To remit the disputed issue to the file of the CIT appeal, to verify the facts and decide the issue after providing the opportunity of hearing. Page 18, last two line.
Yeah, but the IIT itself should have decided it, sir.
Yes, Millards.
All right.
Supplementary item 14.
I don't wish time to file the rejoinder to the counter after file the government.
What's the matter about?
Millard is a field matter, Millard, that the entire 66 acre land has been acquired for the purpose of by the purpose of IDCO for granting them for construction as per by the Vedanta Millard. Millard, I short time we granted the file, but it return Millard.
Who's appearing for 5?
I mean, 5.
You're not filed a reply. Have you not filed a reply?
No, I'll file, madam.
Counsel appearing for opposite party number 5 seeks and is granted 8 weeks time to file a reply. Adjourned to both affidavits of the state as well as the opposite party number 5 be filed before the next date.
IDCO is to record to be filed counter.
6th December. Right.
Millard, IDCO is to record to file counter including.
Yeah. Replies in the meanwhile be filed by IDCO as well. All right.
Supplementary list item number 15.
In that case, my lord, where you also wanted that Moda is another city case. I brought that judgment, my lord. Here, my lord, the petitioner was here before this honorable court, and this honorable court has directed the lordship may see. I quoted the judgment, my lord, at page 6, my lord. Since the petitioner was the unmarried sister of the deceased employee, my lord, she was not given a chance for that, my lord. And this honorable court held that
at page 8, in our considered opinion, while passing the improved order, the authority, namely District Judge Rayagada, has misconstrued this rule to be of the said rules, and unmarried sisters staying with the distressed family should be given the benefit of the rehabilitation assistance has been provided under the scheme. Repeat is allowed. Thereafter, my lord, again, my lord, they called me to give my consent, willingness under Annexure 10 that you are prepared to join at Group D post, my lord. Thereafter, my lord, they rejected my application on the new rules, my lord. The rejection at page 11 I have quoted, and also the order, my lord. That
So why is it before a division bench? Why is this matter before a division bench?
That time it was
or district judge?
the judicial
Yes, yes.
Please, Milords, Annexure 9, Milords, if my lords may see Annexure 9.
This is what has been challenged.
Annexure 9, man.
Annexure 9, Milords.
Notice.
Yes, Milords. The notice that we have sent. Milords, may I read that notice? Pursuant to the order dated so and so of the Honorable High Court, and keeping in view of the Government of Orissa GA and Public Grievance Department with a resolution number so and so, and subsequent notification number 5651 dated 17/2/2020, you are hereby directed to submit your willingness for appointment in Group D cadre employee under rehabilitation assistance.
I think you're saying it can be for both Group C and Group D.
Yes.
Milords, so this, Milords, the notification dated 5651, which is Milords mentioned here, that, Milords, pertains to the new rules, because by that time the new rules had come, and the willingness to come under to apply under the new rules, that notice was given under 9. So, Milords, 9 cannot be seen in isolation that it will pertain to the 1990 rules, because that was clear. Thereafter, Milords, the next page, page 48, Annexure 10, which is the submission of the willingness that has been given by the petitioner. In inviting a reference to your notice on the above cited subject, I beg to inform you that I do hereby submit my willingness for appointment in Group D cadre employee under rehabilitation assistance scheme. Now, Milords, since the matter was today, Milords, in item 4, Milords, the issue whether the 1990 rules will apply or the 2020 rules will apply, Milords, since that is under consideration. So, Milords, today, the rules that stand is the 2020 rules. So, Milords, we have to follow the 2020 rules. Now, under the 2020 rules, Rule 6(2)(b) has a objective criteria wherein certain marks are given, and these are objective. Certain marks are given, and if a candidate secures 60 marks and more, then that candidate gets an employment. If it is 44 and less, then the person becomes ineligible. In this particular case, as per my counter affidavit, if my lords turns to page 7 of my counter affidavit, para 10.
Yes.
About 6th line. Having regard to the evaluation, because before that, my lords, I have
scored only 34.
Scored only 34. So because it is 34, so and it is less than 44, therefore, my lords, it is direct ineligibility of the candidate. So therefore, my lords, the candidate is not qualified to get compassionate appointment under the scheme.
Yes, that judgment your lordship wanted. Supreme Court judgment that Modak Nanda Sethi.
No, that was on a different point, sir.
That was on.
Is that the same? That the death, at the time of death, the prevailing rule will be considered, or the new rule?
So that we have to take a call, sir, because this is pending consideration of a larger bench.
Yes, please.
It will have to wait till the larger bench of the Supreme Court deals with it. This judgment itself notes.
Yes,
have you noticed
para 5.
in para 5?
Yes, there is conflict of judgment. Conflicts of judgments. But here the case date is at 2015, my lord.
That's the very point which is going for the larger bench.
Or your lordship may, can I pray that taking into consideration this judgment, they let them reconsider?
No, they've already considered. Not this judgment. I mean, they will obviously wait for the larger bench of the Supreme Court.
The High Court's order has not been followed in toto. That is the case here. Those cases, my lord, the High Court rejected and they have gone. Here, my lord, High Court has interfered and directed them to that Rule 90. As per the Rule 90, there should be the High Court's judgment is clear. But they waited for the rule to be. That is the only difficulties here.
Question whether the application under the Rehabilitation Assistance Scheme must be considered in light of the rules prevalent on the on the date of death of the government employee or the date of examination of the application is pending before a larger bench of the Supreme Court. With the reference having been made, can you give us that other judgment where the reference
that Santosh Kumar judgment that has been
referred to? Yeah. Where's
not
that
in,
Santosh?
not in this case.
No. In Santosh is a reference made to that.
Yes, my lord. So page para 16, my lord. I'll just.
It's SBI versus Shiv Shankar Tiwari.
Para 16.
Yes. 2019, 5 SEC 600. That matters. Awaiting the judgment of the Supreme Court, larger bench of the Supreme Court, in the above case, the present petition is adjourned sine die with permission to the parties to mention it for listing after the decision of the Supreme Court.
Supplementary list item number 16.
Item 16, my lord. Like item number 4, my lord.
Withdraw.
With the liberty to.
All right. Counsel petitioner seeks leave to withdraw the present petition. Liberty to approach the learned single judge in accordance with law. This post office withdrawn with liberty straight for. All right.
My lord, 16, 19. And at 22, my lord.
16, 19, 22. All right.
19 and 22.
All right.
All right. Supplementary list item number 17.
None appears to sustain.
Supplementary list item number 18.
I don't get this now.
Counter affidavit has not been filed.
Okay, last option to file counter within 8 weeks, rejoinder for the next date. 14 December.
Supplementary list item number 20.
20. In 20, we have filed the affidavit.
Mangala Jodi.
Yes, Mangala Jodi.
Affidavit
has been filed. Copy has not been sought because.
Yeah.
Copy has been served.
No, my lord.
No, copy not served.
No, I can serve it to Mr. Mishra, but I cannot serve him. My lord, that hard copy, should I give it or Hard copy is there.
What is it saying there, sir?
Kindly see, yes. That meeting was held pursuant to your lordship's direction along with the stakeholders.
Right.
That minutes of the meeting and resolutions passed in the meeting, I have annexed as annexure E and F. କୋଉଠି ଅଛି ସେଟା ମ? ଏଇଟା affidavit ଟା କାଇଁ? କାଲିର affidavit ଟା। କାଲି କୋଉଟା? Yes. Proceeding is dated 27th May 2022, annexure E. And tour note of director annexure F. That annexure E is important. Proceeding of the stakeholder at page 11 of my contract. Stakeholders meeting for collecting views on enforcing the ban of motorized fishing vessels in the channels of the Mangalajodi water body area in Chilka Lake relating to WPC number so of the Honorable High Court of Orissa at multi-purpose cyclone shelter, the venue.
No, this is only the view of Director of Fisheries.
Yes.
He says don't have any ban.
You cannot ban.
Para 13.
Para
View of the utmost dependence of local fishermen and use of motorized traditional fishing boats. No restriction of ban.
Affidavit para 13. Yes. That is the view expressed by the stakeholders.
No, only one. Director of Fisheries.
G annexure G is important. Para 11. Para 11 may kindly be seen, page 8. That a meeting was conducted under the chairmanship of Additional Chief Secretary Forest Swanso to discuss the restriction of motorized traditional registered fishing boats in the Mangalajodi area, Swanso. The Principal Secretary Government in Fisheries, Swanso.
So who's counsel the petitioner? Where is he? Mr. Mishra was the Ashish Mishra.
Petitioner is Mr. Ashish Mishra.
Mr. Mishra. Mr. Ashish Mishra.
My lord.
Have you got a copy of the affidavit?
My lord, today I have received in the court hour, I have received the counter
You
affidavit.
examine it. You examine it, make submission. You see, today in the court, an affidavit of the Director of Fisheries has been handed over. Mr. Mishra, learned counsel petitioner, states that he has received a copy only today. Needs time to study it and make submissions.
Date may be given.
September.
My lord.
22nd September.
Okay, my
All right.
Hello, Blast.
Supplementary list item number 21. My lord, 21 may taken up 2 weeks after to file a rejoinder.
All right. Rejoinder will be filed the next day.
In sub item also.
Along with the sub items.
Right. 6th December.
Supplementary list item number 23.
Oblige. Pray for 2 weeks time for filing of a counter as a last chance.
12, sir, 2012 map. What's the matter about?
With your lordship's permission, may I just pass on the facts of the case? I'm sorry, it has been mentioned as written notes of submissions, but it's actually facts of the case.
Can I have a copy?
Yes.
The conciliation failed, and this was the reference made. Probably I've given a wrong copy to your lordship. Right. Then if your lordship will turn over to page 2, the opposite party number 1 workman in his statement of claim had described the petitioner as follows: management of bus number OR 033394. In evidence, it has come that this is not my bus. Mrs. Srimati Vishnupriya Mahanti, Messrs. Kalia Bus Company. Kalia Bus Company is not mine. That also has come in evidence.
I see.
Then your lordship will look at B. It was pleaded by the workman that he was working as a driver in bus number OR 138899, OR 133099, and OSP 2499. It has come in evidence that the second 2 buses, that is OR 133099, OSP 2499, do not belong to me. It belongs to one Rabindra, who has not been made a party to the proceedings. The owner of the bus is the petitioner, and on 24/7/2, he was not allowed to perform any duty by the owner of the above company without any reason or information to him. He had completed more than 12 years of service at the time of termination, and no notice was given. Now, this is our written statement. We have stated that these buses do not belong to us. The workman has not impleaded Rabindra, who's the owner of the buses.
No, 1 minute. This 8899 is your bus.
8899 is my bus. Yes.
But he's not impleaded that bus owner.
And our specific contention was that we used to engage him 1 or 2 days in a month whenever our regular drivers were absent. And he was driving buses of other owners. And this is evident from the fact that he's mentioned these bus numbers which belong to someone else. And he has not been impleaded as a party. Now, if your lordship will look at the evidence straight away, the deposition of the workman, if your lordship will look at page 34. And look at the cross-examination.
Yes.
I have not made party to Sri Rabindra Kumar Mohanty, who's the owner of bus number OSP 2499. I cannot say if any company named as Kalia Company. Now, if your lordship will look at page 36 now, that is another witness on behalf of the workman. Page 36, paragraph 2. The bus bearing registration number OR 033394 and OR 133099 do not belong to the management. I know that Rabindra Mahanty is the owner of the bus bearing number OSP 2499. It is. Now, if your lordship will go to the award, which is at page 18. It starts at page 15. If your lordship will go to page 18.
Yes.
If your lordship will look at about 4 or 5 lines from the top. During cross-examination, MW1 has admitted that the workman was driving 4 buses of the management as per requirement. As per requirement, MW1 has further admitted in his cross-examination that the management is not maintaining the attendance register of the staff. Both the workmen and the management have adduced evidence in support of their respective cases. Now, if your lordship will just leave about 4 or 5 lines and come to it is categorically stated. It is categorically stated by the workman that the management had neither issued any charge sheet nor conducted any inquiry against him for any misconduct before such, according to the workman, he is entitled to be reinstated and so on. And if your lordship will turn over to that, the other page, turn over to page 20, actually, straight away to 20 and the order at paragraph 10. That the termination of service of so-and-so with effect from so-and-so, owner of management bus number OR 131399 and OSP 2499 of Messrs. Kalia Bus Company is neither legal nor justified. I do not have the company. A company is thrust on me. The workman Sri Patnaik is entitled to be reinstated with 25% back wages.
So
Now, you do not make the party the person who's
Kalia company is not yours.
Kalia company is not mine, admittedly not mine.
Yes, sir. What do you say?
My lord, may kindly see page 40. That is the deposition of the management witness, the cross-examination. The para 13. My lord, they have given the previous page. They have not given. They have given only this page. You will also paragraph 30. The workman was driving 4 buses of the management.
No, but which management? Whether it's this management or which?
This management, my lord, he represents the management. He is the management witness.
That's not, see, this is one stray line in the management witnesses deposition.
No, my lord, may kindly see, I have not produced. The management witness says he is the manager. Your lords may kindly mark. He is the manager. Your lords may kindly see page 40. His status is manager of that company who manages. Your lords may kindly see page 40 at the top. His description has been given. He is the manager of the company. He says he drives 4 of our bus. And we have not maintained any attendance register of the workmen who are being engaged for the purpose. So this management admits that not only that, your lords may kindly see, they themselves have filed that the written statement before the Learned Labour Court. There they dispute only with regard to OSP 2499, paragraph 3.5 at running page 30. Though in the reference, 3 buses were named, my lord, but in the reply, they have controverted only regarding ownership of this bus. You will also kindly see paragraph 3.5 at running page 30. That the averments of dispute and workmen paras 1 and 4 of the statement of claims, it is humbly submitted that ownership of the bus bearing number OSP 2499 doesn't belong to the first party management. So they only dispute this. And my lord, it's a fact, my lord, which has been borne out of the pleadings, my lord. Your lords may kindly, with your lordship's permission, can I take your lordships to the deposition, my lord, under Annexure 5 series?
Yes.
My lord. My lord, in the cross-examination at running page 34, it is not a fact. I have not made party to Ravindra Kumar Mohanty, who was owner of bus number so and so. Thereafter, I cannot say if the company named Kalia Company, but Kalia Bus Company. Your lords may kindly see. I cannot say if any company named Kalia Company. I have not received any appointment letter from the management. It is not a fact that I used to drive the vehicle of the management temporarily for a period of 2 or 3 days in a month whenever required. On several occasions, I made complaint to the management and before labor court without not getting the minimum wages. It is not a fact that the management has not terminated my service and I voluntarily did not join when I became old. Thereafter, the next page, the other witness, your lords may kindly see. I know the second paragraph. I know the workmen and also the management. The workman was serving for 10 to 12 years under the management. The management has terminated the service of the workmen without any notice and compensation. Thereafter, in cross-examination, the boss belonging to registration number OR 033394 and OR 13 do not belong to the management. That is what he said. And your lords may kindly mark the reference. In the reference, your lordship will find the boss numbers have been given OR 133399 and not the other one, OR 033394. And your lords may kindly see Rabindra Mohanty is the owner of Boss One. So it is not a fact. I am not deposing falsehood. Thereafter, your lords may kindly see the order passed by the order passed by the Lorded Court below. My lord, I will take your lordships to page finding, my lord, issue number 1 and 2. For better appreciation for adjudication, the dispute of so-and-so. The perusal of the evidence of the workman reveals that he was working for 10 years under the management as a driver. On so-and-so, he was illegally retrenched from the service by the management. In spite of repeated requests, the management has not considered his case and didn't reinstate him in service. In his cross-examination, the workman has stated he has not received any appointment from the management. WW2 has stated that the workman was working for 10 to 12 years under the management. The management has terminated the service of the workman without any notice and compensation. On the other hand, management witness, now MW1, has stated that the workman was occasionally engaged as a driver as and when required by the management. He was never engaged as a regular driver. He was paid for the days he has actually worked for the management. According to MW1, the service of the workman was never terminated by the management with effect from so-and-so. On the other hand, workman voluntarily left the job. During cross-examination, MW1 has admitted that the workman was driving 4 buses of the management. As per requirement, MW1 has further admitted in cross-examination that the management is not. Thereafter, para 8. Both workmen and management have adduced evidence in support of the aspect. On a careful scrutiny and analysis of the evidence, it is clearly evident that workman was working under the management of as driver. According to the workman, although he has rendered continuous service of 10 years, but the management, without any rhyme or reason, terminated his service without giving any notice and notice pay or retrenchment compensation. It is categorically stated by the workman that the management had neither issued any charge sheet nor conducted an inquiry against him for the misconduct before the such termination. According to workman, he is entitled to be reinstated to service back with back wages since provisions of section 25F of ID Act were not complied with. The case of in the case of his termination, the stand taken by the management before the court is that management has not terminated the services of the workman without so-and-so. Rather, he voluntarily abandoned the service. So this statement of the management itself proves that he was in employment of the authority. Thereafter, it is clearly evident from the evidence of the workman that the management, without any rhyme and reason, terminated the service with effect from 24/7/2002, and while terminating his service, had not issued any notice or notice pay and retrenchment compensation to him. The above such fact has also nowhere been challenged and disputed by the management. In such premises, absolutely, I find no cogent reason to disbelieve the evidence of the workman. Rather, I am of the view that the management, without any rhyme and reason, terminated the service of the workman with effect from 24/7/2002, and while terminating his services had not been complied with the mandatory provisions of 25F of the Industrial Dispute Act. The settled position, you lot may skip over. Thereafter, next page. In view of the above legal position, the termination having been made in violation of mandatory provision of section 25F of the Industrial Dispute Act, in my view, is void ab initio. I am therefore of the opinion that the termination service of the workman with effect from 24/7/2002 by the management is illegal and unjustified against the mandate of section 25F. In such view of the matter, the workman is entitled to relief of reinstatement. Admittedly, management has not availed the service of the workman with effect from the date of his termination. On the other hand, there is no cogent evidence adduced by the management that the workman has been gainfully employed elsewhere. So, on careful consideration of facts and circumstances of the case, instead of granting full back wages, I am of the view that 25% back wages will meet the ends of justice in this case. Hence, both the issues are answered accordingly. Hence, order. And in the meantime, after the order of the lower court was stayed by this honorable court by order dated 10/7/2012, the workman was not reinstated. My lord, he died in the year 2016 without
so only 25% back wages now.
That, yes, my lord. He has also not received.
What does it work out to, the 25% back wages?
My lord, he was not working with us. We do not have a company. A company has been thrust on us. The person with whom he was working has not been made a party to the proceedings.
No, one bus of yours he was driving.
He used to drive once in when the regular.
What does it work out, sir? What is the 25% back wages? What is it working out to?
Then because if we implement the award, then the entire till his death, the entire salary has to be paid from the date of the award.
No, but 25% back wages.
No, there's an order of restatement also.
But now there can be any reinstatement.
Yes, ma'am. Only back wages.
The only problem is, I'm not shying away from advising my clients that they should, sit down and negotiate or pay whatever. But the only problem is this man was not working with the management.
It's all right, sir. Otherwise, you'll be in litigation for God knows how many more years.
And just have a look at page 37. We have stated that these buses are not ours. My learned friend says that we are not stated. It's all stated that it's not ours.
No, but your own witness says he was driving 4 of your buses.
4 buses as and when required.
Whatever. And he's there for 10 to 12 years. The witness says that.
Your will appreciate if my regular driver is absent, I bring one driver on casual basis and use him for one day. Then I have to pay compensation.
All right. So what do you wish to do? Want to negotiate and
your lordship may fix it for negotiation. Let the legal heirs come.
All right.
Because this 30% also by
5%. All right. You see, parties are willing to explore the possibility of settlement. The representatives of the petitioner and opposite party number 1 will appear in the mediation center at 3:30 p.m. on 10th August.
But may I just make a prayer that your lordship will only confine it to that 25% compensation? Because that's not possible on our part to pay him a lakh or 2 lakhs of rupees.
Counsel for the opposite party number 1 states that with the opposite party number 1 workman having expired, the relief prayed for would be only in relation to the 25% back wages awarded by the Labour Court. On this aspect, both representatives of the petitioner and opposite party number 1 will appear before the mediation center at 3:30 p.m. on 10th August 2022 to explore the possibility of settlement.
Okay. Very grateful.
All right. List on 30th August, 30 August.
Supplementary list item number 24.
Did you not see? When that appellant's wife said the appellant, you should compromise the villagers. At the spur of the moment, appellant, without any intention, without any preparation, without any plan, he had assaulted.
Madam, you may have to remove your mask because you are not audible and you have to speak into the mic.
A sudden provocation, appellant has assaulted his wife. Google the appellant had no intention to kill his wife, nor he made a plan to assault his wife. So, in absence of any intention to assault his wife, the alleged offense has not coming under section 302 IPC. At best, it comes under 300.
What are the injuries? Let us see the injuries.
Number page 47. Page 47. The evidence of the doctor.
Well, PW
11.
Sharp cut on the nape of the neck.
Yes. 5 injuries. Inside wounds.
3 wounds on the neck. It's not a single wound. 3 sharp cuts.
5 plus. 5.
5?
Yes, 5 sharp cut injuries.
Correct. 4 on the back of the neck and all around the neck. This is not a single injury, man.
But the appellant has no intention. And the spur of the moment,
4 neck injuries. How can you say no intention?
No, my lord, he has no intention.
No point in repeating again and again the same thing.
Well,
you have to explain with reference to the injuries, please.
And 2 sons are the eyewitnesses.
Injuries with a sharp weapon on the neck. 4 injuries on the neck with sharp weapon. How can there be no intention?
No. Without any intention, he has done. At the spur of
Madam, by repeating the same thing even 10 times, the point is not made. You will have to still substantiate it.
My lord, evidence of PW and 7, the inflicted injury is different from the statement of PW Prosecutor 2 and PW 7. No bleeding material has been seized in Tangia. There is no blood stain.
All right. Is there an eyewitness?
The sons, PW2 and PW7, both are sons of both. This is as well as the appellant.
Witnesses. In view of the
PW2 page 31 loss.
Right.
All is failed to prove the best beyond all reasonable doubt.
This categorical state on hearing the cry of my mother.
To be acquitted by benefit of doubt.
All right.
He has no intention to kill. He has all of a sudden his wife intervened and without any intention assaulted his wife. Well, kindly see the decision, which is reported in Lata Singh and another versus State of Rajasthan. Now, kindly have a glance, paragraph 10.
Even the motive is present, no, sir, in the evidence of PW2.
No, there is no motive, my lord. A learned counsel submitted that the allegation in the FIR made against all the three accused persons and the evidence adduced by the prosecution cannot be segregated. Since one of the accused, Bhoga Singh, has been acquitted, then there is no reason why the appellants may not be acquitted from the charge. Learned counsel further submitted that genesis of the incident has not been established, to which injuries were fatal. Learned counsel referred the decisions of this court in the case of Ishwar Singh versus State of UP for 1976, for SCC 355 and State of UP versus Madan Mohan and others, AR 1989, Supreme Court 1519. Learned counsel submitted that non-examination of Gujran Singh and the persons of the locality is fatal. In the instant case, as no explanation has been given for the non-examination. Lastly, learned counsel made an alternative argument and submitted that there was no common intention of the appellants to kill the victim. It may be that because of some dispute and quarrel between the appellants and victim, the appellants might have tried to teach lesson to the victim, and in that they have allegedly inflicted injuries which have caused the death of the victim. And in the said premises, the conviction of the appellant may be altered from Section 300 IPC to Indian Penal Code to Section 304 Part 2 Indian Penal Code, the most under Section 304 Part 1 Indian Penal Code. And a petition is very important. He is in jail custody in 12 years.
Orders reserved.
Well,
Anything more? Tell us.
I will give written note argument.
All right. A written note of arguments be submitted within 1 week. All right.
Supplementary list item number 25.
May I please your last? May I please your last? Sub item to IT appeal number 88 of 2018.
Yes.
Your lordship, by order dated 13/4/2022. Fix the date of hearing on 12th September 2022.
All right. List on 12th September. All right. Both matters.
Both 12th September.
Yes.
Both the same question.
Same
question about
right.
same facts.
Correct.
12th September.
Which is that number? ITA number?
The ITA number. More my case is IT 81.
My case is 81 of 2018. The first matter.
My case is 88 of 2008.
Right. 12th September. All right.
These are identical.
All right.
My lord, 12th September.
12th September.
Supplementary list passed on matter item number 10.
So these are a batch of 16 matters. And these matters will take some time because I'll tell your lordships why. Because there were 168 workmen. In respect to all these 168 workmen, there was a reference to the industrial tribunal. Now, after the reference, immediately after the reference, 10 of them were retrenched by the management. Now they started an independent proceeding before the industrial tribunal. And in respect of these 158 workmen, the industrial tribunal passed an award that they should get temporary status and should get the wages as per the regular employees. This was challenged before your lordships, before a learned single judge of this honorable court. And the learned single judge only set aside that order, that part of the award, which said, consider regularization. But as far as the order for temporary status is concerned, that remained untouched. They challenged that order before the division bench of this honorable court. The division bench confirmed that order of the learned single judge. The order of the division bench was challenged before the Supreme Court. The Honorable Supreme Court, as an interim measure, directed that we are issuing notice, but you implement the order of the single judge, that is granting temporary status. Finally, it was converted into a civil appeal, and the civil appeal was dismissed. Now, with respect to these 10 workmen, the tribunal, same, identical. In fact, if your lordship will look at the single judge order, the single judge has dealt with it, that these are 168, but subsequently 10 of them have gone away. Can I just pass that single judge order? Because that would be relevant for your lordship to understand the award.
You want these people also to be given the same benefit as the single judge?
No, they were not given the same benefit.
No, you want them to.
They were supposed to get the same benefit. Today, they are denied that benefit. And the sole ground is that they were working in the project circle, and therefore the maintenance is an independent circle. And since that work in the project circle has been completed, they cannot be reinstated. Whereas that has been dealt with by the learned single judge in its order with regard to that granting of temporary status. Because I have to show a few judgments to your lordships. If your lordships can put it up on some other day.
All right. At the request of counsel for the petitioner.
Could your lordships be kind enough to put it in the month of October?
Yeah. 12th October?
Very well.
All right. 12th October. All right.
Very great.